Yes, may I mention, my lord, matter, my lord, to be listed after vacation, my lord, not now, my lord. This is a matter, my lord, which is covered by the judgment of Honorable Division Bench. There are
Give it, give
several,
it,
my lord, about
give
10
it. We'll see. After vacations, please give. Give the lists. We'll see.
after vacation, my lord. Not to fix on any date, my lord.
Fixing date will not be possible. You give it. We'll accordingly incorporate it in the list. Give it.
But similar prayer, but inclusion in your lordship's list after vacation.
Yes, yes, please.
Lordship,
May I
please
add
give.
to the Supreme Court judgment this also, which is referred to in
দিয়ে
the
দিন তো তাহলে দেখে নেবো একটা। Yes, please give.
Lordship, may I permit you to mention item number 47, Lordship? It's a
Uh,
very urgent matter that
It's there in the list. Will be taken up.
Lordship, any time today, any time at your Lordship's convenience.
What has happened in it?
Actually, the demolition land belongs to Jela Purusha. Lordship remembers I had mentioned up 2 days earlier.
Very
So-
well. It will be taken up.
Sir, Lordship, any time, Lordship, at your convenience.
Ensure that your other side is here.
Yes, I've already informed. If your Lordship directs and time fixed, then I will
No,
just.
no fixing of time because there are other matters also. Please keep a watch on the list. It will be taken up.
Okay.
The inclusion and upgradation, one reason is the bank account has been attached.
Please give.
I'll not trouble, not at the cost of the reputation. This matter, item 41.
It will
I'll just indicate. The earlier order was directing to appear as a fixed matter at 10:30.
appear under the same heading.
It's
It is
under the
there.
same heading. My only difficulty is that 31st December, the scheme will
It
expire.
will be taken up today.
Great.
Ensure the presence of the
He
other
is there. My learned friend
That's
is
it.
sitting there, Mr. Tonoy.
Chakravarti will take it up till first half.
Otherwise, you see, tomorrow is the last day. We will secure the money and it's a 10 minutes. Then I'll just,
Very well. I'll direct consideration and thereafter it will be between you all.
My lord, mentioning for upgradation in the list, the matter is appearing in today's list as item number 479. And my lord, the recovery letter has already been issued and bank attachment of the petitioner has already been made. That's why if the matter could be heard, then
479
yes, my lord.
দিয়ে দিন দিদি কালকে আর্জেন্টে দিয়ে দিন। I'll have to see.
My lord, may I well ask you kind leave to mention one matter. In this matter, in the month of July 2024, the honorable they have challenged the show cause notice. The honorable court will please to direct the petitioner to participate in the proceeding, direction
not
for
to pass.
affidavit, and not to my lord as that matters. Now, in the problem is that my lord order has been passed. Now, for the year 2018 at the last date to communicate the order or to upload the portal is the 31st December. But we have to that extent we have filed an application. Tomorrow is the date has been fixed given in the representation.
No, but if there is an order of the court, that last date will not apply.
But the thing is that we have also intimated to the department. But thing is that since there is no stay in the order, court has only direct
What is the order?
order.
Is the
Court has honorable court has directed that you pass the order, but you will not upload or not communicate the order.
That's
to
it. You are not communicating.
Now,
That's not a problem.
we have also intimated the department, but departments for being a safe side, they want to so that the petitioner or the other side they cannot raise this point.
They cannot raise that point.
Because
They cannot raise.
I have filed an application. Your lordship, kindly, my lord.
Very well, but not this side of the vacation. What is there in the application? It will be decided whenever it will be taken up. It will be clarified. Not a problem.
If your lordship kindly allow, at least I can satisfy the department. I have mentioned, my lord has please to allow the mentioning. Matter will be taken up during the grateful, my lord.
Lordship, may I be permitted to mention? Lordship, I'm praying for an extension of the interim order. Lordship, 3 of the matters are connected and
Please give extension of interim order. Please give. Kalke diye deben didi.
My lord, may I have my lord's kind leave? My lord, to mention one matter pertaining to the determination of my lord Justice Hiranmay Bhattacharya. My lord, we have served upon a notice.
Today.
Yes, my lord, that's my lord our information. My lord, we are told that my lord is having my lord the urgent determination of Justice Hiranmay Bhattacharya today.
Only till yesterday, not today. It
Oh,
was there till
great.
yesterday. Yes.
Great, very good. My lord, grateful.
number 1.
1 minute, I am for the petition.
Say for corrections.
Yes. What is your name? His name is not there. He was there. ছিল ওর মনে আছে কারণ উনি ইয়ের হয়েছিলেন না এদের অনেকগুলো ভুল হয়েছে মানে ইয়ে নাম ভুল হচ্ছে কস্ট টাইটেল ভুল হচ্ছে
No time for the petition. It will withdraw my lord.
Oh,
It is withdrawn.
that yesterday's. Yes. Mr. Should not.
এই তুমি আছো তোমার আমি পাশে আছি তোমার স্ট্যাটিক থেকে
তাহলে উনি বলবেন না নাকি?
কিন্তু ইন্টারিম অর্ডার আছে দিয়ে দিয়েছো মনে হচ্ছে
এটা অপোজিশন দিয়েছিল এটা মানে ইয়ে দ্য পিস ঠিক আছে
Yes.
But this is for extension of interim order. But interim order is expiring at the end of December.
লিখে নিন this matter is appearing under the heading extension
Item number 4.
Lordship, for the extension of an interim order.
affidavit in reply you have not filed.
Lordship, we are yet to file the affidavit.
When will you file? You are enjoying interim order.
Lordship, with this matter, there are other two matters which are connected. In the
That
earlier
is no
petition,
excuse. Your reply should be there. Every matter is a
it has
separate
to be
matter.
filed, Your Lordship, it will file,
When will you file?
Lordship, in the earlier location, in another matter, Your Lordship was pleased enough to extend the interim order till January 2026. So in that order, to file the affidavit in reply, we have been granted till the after the Christmas vacation, we will be filing the affidavit.
This matter is appearing under the heading extension of interim order upon being mentioned therefore.
Lordship,
Item number 3.
Lordship, I have challenged an order which has been passed in violation of principles of natural justice only, Lordship. The order was passed in pursuance of a so-called notice which was issued to me, Lordship. After the so-called notice was issued, I made a detailed response and I specifically asked for the personal hearing to be granted to me, Lordship. But that was not given to me, Lordship. That is first point of violation of principles of natural justice, Lordship. Secondly, Lordship, the standard operating procedure has been prescribed in pursuance of section 144B, Lordship. Standard operating procedure lays down the manner in which the so-called notice has to be issued, Lordship. After collection of the information, etc., by issuing the notice under section 142(1), Lordship. In the so-called notice, for the first time, certain issues were raised, Lordship, where there was no information asked for me earlier by way of any notice which was issued to me, Lordship. And after this, in the so-called notice, the information was asked and I was asked to submit the response, and I did submit the response, Lordship, and thereafter the addition has been made without granting any opportunity, Lordship.
Yes, Mr. Dudhoria,
Lordship,
personal hearing.
Lordship will kindly come to the assessment order. Page number 86. And your Lordship will kindly straight away come to page number 87.
87.
Yes. The details of opportunity given not Three times opportunity was given. He has filed his reply. The reply was duly considered, and thereafter the order was passed.
No, but physical opportunity of personal hearing
No, opportunity of personal hearing always not required.
before assessing officer, yes,
Not
definitely.
if he thinks not because he was asked to produce some certain document. Not
No,
he
no.
has produced that.
Personal hearing should be granted. Personal hearing should be granted.
Because the Lordship will kindly have a look at his prayer regarding personal hearing.
Show me.
Lordship, page 83. 83, the last para is specifically Lordship.
There is a prayer, page 83.
Yes.
And this is recorded in the order also. This reply is there in the order also, Lordship.
It has been recorded. Lordship will kindly come to.
Yes, but where has the opportunity been granted?
Personal hearing will not. No, it is admitted the personal hearing was not granted, but his reply was duly considered.
No, personal hearing has to be granted. If he has asked for it specifically, then it should be all the more granted. All the more reason why it should be granted.
In that case, may I take instruction of why it was not granted?
Come back tomorrow.
Not
Tomorrow. Small matter only on this ground.
second. I have to take.
Come back tomorrow. We'll
No, I have
finish
to
it.
take instruction. Sometimes if the officer not
On the second, he wants to
I'm
take it.
available.
Very well.
Lordship, item 31 is connected. That is a penalty order, Lordship.
Both are
Item
connected.
31 today,
Both
Lordship.
matters will be taken up on second. Both are similar. This is a consequence
Very well.
penalty order.
लिखून तो दीदी
Bullet 6 and 30
And-
are connected.
अच्छा दीदी
Lordship, item 31
penalty proceedings.
penalty.
31 টাও একসঙ্গে দিয়ে দিন দিদি 31 টা ওর সঙ্গে দিয়ে দিন
Affidavit of service.
Separate order.
Lordship, affidavit of service.
affidavit of service filed today difficult Mr. Dudhoria physically personal hearing opportunity sought not given
Grateful, Lordship.
unless you come back and say yes we have
That's why one chance I will.
please wait let 31 be देखिए 31 एंड फाइल करिए
Yes.
দিদি এই 31 এ একটা অর্ডার রেকর্ড করে নিন This writ petition lays challenge to an order dated September 29, 2025. Sorry. This writ petition lays challenge to an order dated September 29, 2025, passed under section 271 AAC capital within bracket 1 of the Income Tax Act, 1961, whereby along with a notice of demand under section 156 of the said act for the assessment year 2023-24, whereby penalty has been levied on the petitioner
Is 53 Lordship, 38,66,000.
Yes.
The details reply was given.
As a consequence of an assessment order dated March 20, 2025 being passed against the petitioner. Full stop. It is submitted by learned advocate. Bus. Yes.
I'm the petitioner, my lord. He has to take
Yes,
instruction.
Mr. Bhattacharya. Why once it is stayed, how can they impose interest and all? How can they adjust?
But his statement is correct, that only that one submission may I made. That he has filed the appeal in the year of 2016, and that for the assessment year 12-13, and for that assessment year the demand had been adjusted. Now, if your lordship also please to direct the CIT appeal to dispose of the appeal, because the adjustment has been made with the for the assessment year 12-13, and 46 lakhs and odd that has been adjusted. If your appeal has been disposed of, his 20% and he succeed his 20% and adjusted amount, that maybe also be refunded to him. Because this is I believe this is the best solution, because the already amount has been deducted. Now it has been deducted by the faceless, and it is my understanding that it is get difficult for my learned friend to after passing oral also to to get the amount refund. And if your lordship so please to direct the CIT appeal to dispose of the appeal, so that everything can be solved finally.
Is there anything else to be adjusted, or entirety of it has been adjusted?
No, this is
My lord, my learned friend has cleverly placed the case, my lord. And the only difficulty is that for the assessment year 13-14, you prefer an appeal. In the year 2016, we have deposited more than 20%. And as well as for the 2024 and 25, they have noticed 245 notice without giving any opportunity of hearing. He has adjusted AO's comments in favor of the assessee. We have submitted everything. Then also they have CPC has deducted, my lord. My lord, how can we say, my lord, we assessee is for 2016, we are in 2025. After 9 years, my lord, how can this is they are cannot take the benefit of their.
And if
It is not the way
and it
it
is
should
also
be run.
beneficial to him, Milord.
No, no, I'm
amount
grateful to
he
my lord,
has
friend, my
to
lord,
put the
only
clock back. Refund has to be granted.
refund has to be granted. My lord has passed in many orders. And recently also, I can have no the copy of the order.
I will direct disposal of the appeal also, but
Yes,
that is illegal.
there is- Well, this is the copy.
They have stayed the order and then
Not, Milord,
Well,
written it.
as well as they have also collected interest, which is not
if the
an
refund given
so
to him
interest of
after the
41 lakhs.
appeal disposed of, Milord, he will
For
also
the,
get
they are
interest.
my appeal is pending on 2016. They are charging interest on that. This is unbelievable
After
thing.
dispose of, you also get the interest.
I will direct disposal of the appeal.
Yes, Milord.
My refund may be granted.
But why are you mentioning now? Mention at the time of rising 115 or in the meantime, in the midst of matters, don't mention like that.
No, I have the petition. Calcutta appear calling. This is the EPD service. But central is the answer. Central is the answer. Yes, absolutely. Yesterday also they didn't appear.
Yes.
When without.
You were there.
No, well, he's not there. Since I found that something is on the central GST is going unattended, I requested him to at least.
Yesterday also nobody appeared.
What is the matter?
The levy on IGST on the ocean freight, madam. Whether it was declared ultra-biased to the Constitution by the Honorable Supreme Court in case of Mohit Minerals. Subsequently,
Till now, I am not. I'm ready.
And I found something is going unrepresented for the department since he is doing a standing counsel for the department. I said, at least take note of the matters and inform the client so that the matter will not go on. He is not in the matter.
Can you come back tomorrow then?
I can copy the
Come back tomorrow.
Grateful.
Not to go to the Calcutta. Next.
Grateful.
My lord, the petition. In this matter, my lord, I am challenging the GST order of GST registration cancellation and also the focus notice. There are several infirmities in the focus notice as well as the job. Kindly come at page 39.
39. 39. Yes.
This is the focus notice that is served on my client. Kindly, whereas on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following. Then, section 29 2E, registration obtained by means of fraud, willful misstatement or suppression. There is no elaboration or no document is annexed with this. And kindly see at the bottom of this page. There is no signature. It was signed digitally signed by PS Goods and Services Tax Network GOC. So this is a document in which my client is asked to focus as to why his registration should not be cancelled. But without any basis, without any document, without any information, and there is no signature, and there is no mentioning of the DIN. No DIN. Now, along with this notice, one page document was also uploaded or served, and thereafter, though I have not liable to submit any reply in respect of this vague notice, I filed my reply to show my then there reply was filed. Thereafter, 2 reminders was also filed. When no hearing was granted, then my client has no other option but to file a writ petition before this honorable.
Yes.
That writ petition is at page 72. In the reply and in this writ petition also, I have challenged the focus notice by stating that this focus notice is vague and cannot stand. Then this honorable court was pleased to remand the matter before the authority to decide the matter on which. That is at page 8. Yes. That is the kindly note that this order is 29th of October 2024, and immediately thereafter I have informed the Assistant Commissioner CGST to give me here. Then the hearing notice was at page 88. The notice for personal. Kindly go through the notice, my lord. With reference to court order of WP number such and such, the Assistant Commissioner. Kindly note this, the Assistant Commissioner Barabajar Division, CGST and CS Kolkata North is pleased to grant personal hearing on 25/11/2020. Thereafter hearing was granted and no order has been passed. Then I have to file one application for contempt application. And in that application, the court was pleased to pass an order, which is at page 101, to direct the authority to upload the order in the portal, or to communicate the order to the petition. Then I have received one letter, which is at page 103, dated 5/3/2020. With reference to your letter dated 22/2025 received by this office on 5/3/25, as per order dated 26/2.
Order has been issued. Read it. Yes,
Yes,
then
order has been issued. Kindly look at the order. This order is an order of cancellation. It is only a repetition of the allegation or whatever is stated in the focus notice. And thereafter, at the bottom of that page, kindly see the superintendent. His name is appeared here, and there is no signature. Thereafter, your lordship, and along with that, one report has been also given to me, though we have not given any chance to revert that report. And then kindly come at page 100. This order, my client, tried to that as 109. From the portal, he has downloaded this order, and at the bottom, it is shown that is a page 1 or page 2, and kindly turn the page and come to page 110. There is no signature, nothing, and it is stated at the bottom of that page. This is a system generated. And thereafter, your lordship, at page 111, the same order, kindly come to page 112. There is a signature in there. So my humble submission is that the focus notice has no legs to stand. There is no, only the allegation is made, and there is no signature appended to digitally or personally. And may I have your lordship's kind attention to one decision of the Honorable Bombay High Court.
yes.
Kindly come at page 2.
Yes, I've seen it.
Then at paragraph 6, your lordship.
Yes,
And
system
at paragraph
generated
9,
documents.
the High Court was pleased to restore the registration. And thereafter, my lord, I have other decision on this issue of several High Courts. I am not traveling your lordship with that. And now I am relying upon one decision of this honorable court, honorable division bench's decision. Kindly read from paragraph 3 onwards. May I place it?
No, no. Yes.
Kindly come at
I've read it. I've read it. Particulars not given.
particulars not given, and in this the important thing is the honorable division bench kindly come at the line 6 line of page 4 that starts from in any event.
Line of page 4.
Page 4 that starts
Page 4 of?
page 4 of the decision of the honorable division.
Page 4 is blank. 3 pages only.
Sorry, page 3.
Page 3. In any event, yes.
Yes. In any event, issuance of show-cause notice is not an empty formality, as the notice is entitled to have an effective opportunity.
Yeah, I have read that. I told you. It's settled. That is settled.
Yes. My
Yes.
humble submission is that my lord kindly set aside the show-cause and the order.
You are appearing, Mr. Banerjee? Yes. Yes.
So far, he has shown two judgments where it is technically passed. Should be, in fact, the single bench of my High Court is also of the opinion that unless business is hot and allowed to run, I am losing, nation is losing generally. So on that score it is. But when someone takes a registration for a fraudulent,
That's right. That's all very good. But how have you proved that he has
Lordship,
the order
I
offers precious little on this?
even in document on opposition latter.
Not required. In document on opposition, if you have something in the order, first of all, that's settled. Mohinder Singh Gill is now known to everybody. You cannot.
He is completely aware of what he has done. And he come to page 105, his own document. Yeah, he relaxed.
Page
It is
105.
there in his portal.
This is not my own document. This is before.
Page 105. Yes.
Right, thanks. The connection of anti-evasion, this is made only the paper transaction and investigation against such and such was initiated. The order of anti-evasion, Kolkata not visited the premises such and such, it was fine.
What is this document? What is this?
Lordship, this is his portal document of anti-evasion raid at his place.
So what? Raid is not an order. Raid it's only a method to collect an evidence. How has that evidence been scrutinized, and what is the result of the scrutinization of the evidence? Scrutiny of the evidence.
The thing is,
Mr. Banerjee, the order is indefensible. You can go on submitting. I have made it clear to you. The order does not show any reason. The order does not show any non-application of mine. His reply to the show cause has not been considered. All of this being there, I mean, in the order, how will you support it by making submissions or even by an opposition?
There's a concept of if I go stretch my case very high, that he has got everything. Lordship, this document.
He has not got everything. You have not provided anything.
Lordship,
That is the problem.
Is page 105 to 108 conclusively says that
105 to 108 is only an evidence. It's a piece of evidence that is required to be assessed by the proper officer at the time of adjudication, which is absent.
Very case that there is a evidence on the table of the court court can look into it post facto or post order reasoning if they want, we can give it. But Lordship is today, Lordship allows his application, set aside this. Then Lordship, this piece of evidence which he has filed before your Lordship is disclosed so that he should not come under suspicion. Clearly shows that he has evaded my 9 crore.
That is still an evidence. Where is the consideration of this piece of evidence which you are relying now? You are relying on this piece of evidence because it forms part of his application. Show that this piece of evidence has been considered by the proper officer in the order which is impugned in the writ petition.
Suppose he is siphoning fund from my bank.
Sir, these are all submissions. This is an allegation, maybe an allegation which cannot be refuted. It is an irrefutable allegation, but somebody has to come to this conclusion.
No, Lordship, but first I have to stop and cancel. And then Lordship I have to continue. Then I
No.
will allow
Then
you
what
to-
is the use of the show cause notice?
Then
Then you could have stopped it at the threshold. Why do you use a show cause notice, and why this proceeding is required? Mr. Banerjee, these are fantastic submissions. I mean, out of fantasy. You also know that they are not entrenched in law. We have read it from our childhood that when an order is passed, it has to, the bare minimum which it has to do is to show application of mind to the matter. It is to show that evidence which is there before the court has been scrutinized, analyzed, and the court has reached a conclusion. If it is an erroneous finding of fact, as a writ court, I will be loath to interfere. I'll say no. There is a
the recording of the entire thing. Lordship,
this is the recording. This is the recording. That is the order. That is what is. He will not challenge the records. Something which you keep inside your mind. I am not probing the mind of the authority. It is the decision-making process which is under challenge. Now, what is there? What is there to show that?
Lordship, good, bad, indifferent. Lordship,
Everything bad, nothing good and nothing indifferent. With this kind of an order, he has simply copy-pasted the show cause notice, and he has said that he has filed a reply. He has filed the reply to the show cause. Where is the consideration of the reply?
Lordship, maybe let's proceed. This is an error,
No.
fault, felony, whatever. It is a mistake is being there. Lordship is there to set this. But now Lordship,
Somebody's mistake costing somebody's business. It's
Lordship, I mean, that's
some application of mine should be there. He'll have to decide this again. He will revisit it. He will revisit it. This order, I cannot. I'll be doing greater injustice by sustaining this kind of an order. This cannot stand. Mr. Sengupta, your show cause notice I cannot interfere with. The reason is the earlier order. It's barred by constructive res judicata. You approached this court by filing a writ petition challenging the show cause notice. The writ court did not interfere with the show cause notice and sent this matter back. I was waiting for Mr. Banerjee to take this point. He has been arguing on the basis of the order. Show cause notice stands because it's constructive. I could have interfered with it if the earlier writ petition had not spoken on that. The first line of the order which you showed says the present writ petition has been preferred challenging the show cause notice. If a challenge is thrown and there is no positive finding on the challenge, it means it is negated. Challenge to show cause is negated. You have been relegated to the hearing authority for a hearing on the basis of the same show cause. That show cause has been upheld here. So I am not interfering with that. This order will go. That's all that you can get. You are saving your show cause. He is getting his order. Mr. Banerjee, it's vacation time. You know this order.
Lordship, this cancellation should be not set aside forever.
I'm setting aside this order. It is at the stage of show cause. Now he will consider his reply, hear him, and pass an order.
Lordship, that I will
No post decisional hearing. That is in better cases, not here. Yes. Yes.
May I please, my lords? My lords, this is a covered matter, my lords. This is a cash seizure issue under the GST, my lords, pursuant to a search and seizure
That has
proceedings.
been seized.
Yes, my lords.
And you filed
No,
a report by
No, my lords.
Submit before that, my lord. This is probably it will be a covered matter because in this matter, the so-called issuing authority as well as the adjudicating authority
Yes.
comes to a definite conclusion that the sale proceeds are the proceeds of clandestine removal of goods, and that amount has been appropriated towards their duty liability.
So it falls within the purview of that section 67.
It exactly falls outside the purview of my lords. I was coming to that, my lords, because on other matters, my lords had sought a report, my lords. Now, in this matter, my lords, in my matter, because I waited for the show cause notice and the order, my lords, from the findings, it would be palpably clear that what has been what has been seized is basically unaccounted proceeds as per the department's case. It is unaccounted proceeds from clandestine sale of goods as alleged, and that, my lords, is clearly being held to be outside the purview of section 67, my
It is
lords.
unaccounted.
Yes, my lords, that is precisely their case, and I'll take my lords through your lordship's order, wherein in the report, this was the precise reasoning that this is on account of clandestine activity, sale proceeds on account of clandestine activity, and my lords is extensively quoted Delhi High Court in Khandelwal traders, and thereafter come to a conclusion that no, this kind of a seizure is not permitted, my lords. This kind of cash can't be seized. But may kindly be allowed to place, my lords, your lordship's judgment in Pushpa Furniture, my lords.
That may be wrong. Let us go by the section.
My lords, my lords, my lords. Section is also enclosed, my lords. In my compilation, my lords, I have also enclosed the provisions, my lords.
He can do so if he is of the opinion that it shall be useful for or relevant to any proceeding.
Yes, my lords. And my lord had even cited an instance from the Delhi High Court judgment, my lords, where it says is what is useful. Basically, assuming a currency note number can be traced to the investigation, only then in that event it can be held to be useful. But if it is merely unaccounted proceeds from clandestine sale of goods, as well as that can't be falling within the purview of section 67, my lords. May I just kindly place two paragraphs from your lordship's judgment, my lords, because my lords has read section 67 briefly. It should be useful for the purpose of investigation, my lords. Kindly takes your lordship's judgment, my lords, which is starts at page 24, my lords. My lords, may kindly takes page 7, my lords.
Page 7.
Page 7. Page 7 is the relevant extracts of the report, my lords. In terms of the said order, this is, my lords, quoted in your lordship's order, my lords. In terms of the said order, a report in the form of an affidavit has been filed, which reveals as follows. It is stated that the detention of cash of rupees this was done, considering it as unaccounted cash against clandestine supply of taxable goods and services without any bill or invoice, for the reason that the person in charge present at the time, namely this, could neither explain about such receipts satisfactorily nor did provide any documentary evidence, transactional receipts at the time of search in support of it being related to any legal transaction. The cash was seized as a part of the investigation on the ground of the petitioner not being able to explain the huge cash which is unaccounted in his premise, and on the reasonable belief as unaccounted cash against clandestine supply of goods and services without any bill or invoice. The seized cash is kept under the custody of the petitioner in his premises. Now, my lords, kindly takes page number 17, my lords.
17.
Yes, my lords. I'm just quoting the relevant extracts, my lords, to make it as brief as possible, my lords. Which is an extract quoted from Khandelwal, my lords, Deepak Khandelwal.
Yes.
Paragraph 46 onwards, my lords. It is clear from the scheme of section 67 of the Act, the word things is required to be read ejusdem generis with the preceding words documents and books. It is apparent that the legislative intent of using a wide term such as things is to include all material that may be informative or contain information which may be useful for or relevant to any proceedings under the Act. Although books, documents and books are used to store information, they are not the only mode of storing information. There are several other devices that are used to store information or records such as pen drives, personal computers, hard disks, personal computers, hard disks, mobile communication devices, etc. The word things would cover all devices and material that may be useful or relevant for proceedings under the Act. The word things must take color from the preceding words, documents, and books. It denotes item that contain information of record which the proper officer has reason to believe is useful for or relevant to the proceedings under the Act. The context in the word things is used makes it amply clear that notwithstanding the wide definition of the term things, the same is required to be read adjustum generis with the preceding words. It is apparent that the legislative intent in using a word of wide import is to include all possible articles that would provide relevant information, records, and material which may be useful for or relevant to the proceedings of the Act. We are unable to accept the word things must be read expansively to include any and everything, and notwithstanding that the same may not yield or provide any material useful or relevant to any proceedings under the Act as contended on behalf of the revenue. My lords, may kindly takes paragraph 56 thereafter, my lords, on page number 19, my lords. There may be cases where the revenue finds a particular currency note or any particular asset has evidentiary value to establish revenue's case. Illustratively, a delinquent dealer supplies goods without invoices only on presentation of a currency note, because the note would, my lord, bear a number, and it is to correlate the transaction that this note would be required. Now here, my lord, what is the case? It is the case of the revenue is that I have clandestinely supplied goods without issuance of invoice, and this proceeds which has been seized from my premises is on account of such clandestine removal. Barring that, this has got no evidentiary value. And my lords, insofar as that particular observation is concerned, why my lords had directed for furnishing of a report in such cases? Because it was at the stage of seizure itself. Now, my lords, in my case, what has happened is the cash was seized. I wrote to them. They did not. They directly issued a show cause notice, confirming a demand to the tune of 33 lakhs. 30 lakhs on account of clandestine removal, 33 lakhs on account of ITC. I replied to them saying that you don't have authority to seize such cash. You please refund this cash. Then they pass an order, not only saying that this cash is something which can't be seized, they appropriate it towards the demand amount, my lords. This is not in the nature of tax. And my lord says categorically. Sorry? My lords, Deepak Khandelwal, my lords, the Delhi High Court judgment categorically holds that Section 67 is not a tax recovery provision. It is just to unearth tax evasion, my lord. May kindly takes, my lords, the order, my lords. First of all, my lords, show cause notice, my lords, page 51 of my writ petition, my lords. Page 51, my lords, para 3.2. This is an extract from the show cause notice, my lords.
Yes.
On the same day, that is, this search was also conducted at the factory premises of so and so, situated at so and so. During the course of search, some documents relevant to the investigation, along with Indian currency, amounting to rupees 1,39 lakhs 7,110 were recovered, and statements of the concerned person were recorded. Now, my lords, what is this cash on account of, my lords? Kindly takes page number 79, my lords, of my writ petition.
79.
Yes, my lords. Para 5.1.14, my lords, last paragraph.
5.1.1.
From the above, it appears that Mr. Shamshil Manufacturer is engaged in clandestine sale of goods, as evident from the seized document number this, and the cash recovered is nothing but sale proceeds of the clandestine sale of goods. Now, my lords, this was the show cause notice. Now, kindly takes my order, my lords. Order starts at page 145. I'll just take, my lords, to the relevant portion, page number 178, my lords. This is relevant portion from the order, my lords.
Well,
para 8.10.
Yes.
Well, so I had cited few judgments on cash can't be seized, my lords. What they say is that first of all they deal with the judgments, and my lords, in the latter part of this paragraph, my lords, sub paragraph 1, in this case the investigating officers had sufficient reasonable belief that the unclaimed cash might be sale proceeds of clandestine clearances, and it would have been a wrong decision not to seize such a vital evidence. And then what they do is, my lords, kindly takes page number 182, where they appropriate this amount towards the tax demand, my lords. I order that seized cash to be adjusted. My lords, is that page 142, my lords? 182?
Yes.
My lords, serial numbers, para C.
C.
I order that the seized cash to be adjusted towards the above confirmed liability of tax, interest, and penalty imposed as per the existing laws and procedure of cash seizure. Seizing authority should calculate interest with confirmed demand and 100% penalty, and that should be debited from the seized cash to the proper GST exchequer with intimation to Assistant Commissioner, blah, blah. Further, if any seized amount left after adjustment of confirmed liability and this imposed, that to be refunded by the seizing authority to the taxpayer. Now, my lords, I have challenged this order also on payment of 10%, which entitles me to an automatic stay, my lords. Now, my lords, in that event, how can this cash be seized, given that this has no evidentiary value? This is merely
Mr. Banerjee or Mr. De, who is appealing? Yes, Mr. Banerjee.
Well, over here, first of all, Malad, the order in original is self-explanatory with regard to the manner in which the cash has been adjusted. Lordship will kindly see the order in original has been passed on 1st February 2025. Malad, the writ petition has been filed.
22 May.
Has been
22nd,
affirmed on 22nd May 2025. Beyond the statutory period of limitation. Secondly, my lord, the
may I kindly indicate this is which he's talking about the statutory? I have challenged the demand in an appeal proceedings. So therefore, I'm not on the appeal against this order.
An order cannot be segregated that one portion will be challenged before your lordship and the other portion will be decided by the appellate authority. Let the appellate authority decide the issue within a reasonable time.
My lord,
taking all the points.
May kindly indicate, my lord. My lord, there are two parts to it. My lords, insofar as the demand on account of clandestine clearance is concerned, my lords, that is an entirely factual exercise for which I am not troubling your lordships. Now, my lords, insofar as seizure is concerned, that is a separate cause of action arising from a separate provision. Now, if they have illegally appropriated or adjusted this amount against my demand amount, would that preclude me from approaching your lordships, my lords?
No, but Mr. Dhanuka, Mr. Banerjee has a point in it. When you have challenged the order in original, the entirety of it
my
is
lords,
before the appellate.
Yes, my lords. And what is entirety, my lords?
Which includes seizure.
My lords, which is the difficulty, my lords? So now,
adjustment.
Which includes adjustment, my lords?
It includes both.
Not the seizure, my lords. My lords, because the demand there is only to the tune of.
What is the purpose of seizure?
My lords, exactly.
The purpose of seizure is to collect evidence.
Evidence.
To collect evidence.
Yes, my lords.
That evidence is to be utilized where? In the adjudication.
My lords, I'm assuming, my lords, kindly just bear with me for a minute, my lords.
The evidence will be utilized where? In the adjudication proceeding.
And which
the adjudication proceeding will be culminated in what?
Into an order. Yes, my lords.
It has culminated.
Yes, my lords.
You have carried the order in appeal.
Yes.
The entirety of this is before.
Yes, my lord. My lords, kindly takes for an instance, my lords, assuming that this was not cash, my lords. Assuming for a moment this was not a cash, and we are coming from the same provision, section 67, which allows them to even seize goods, books, documents, things, records. Now, my lords, once it is a document, once it is a goods or things which is not being relied upon for the purpose of bringing about their case, can they seize it, my lord? Section 67(3), my lord, kindly takes.
No, whether they can seize it or
no, they have to return it, my lords.
Is a question, right? They will have to return it.
Yes,
that's all very good. But do you say that the appellate authority is powerless to direct that?
Yes, my lords. My lords, why I say that is because this is an independent. What I'm challenging before the appellate authority is the order.
Which I'm not with you, Mr. Dhanuka, on this.
My lords,
the appellate authority has power to adjudicate upon any order that is passed by the proper officer.
Yes.
Then in that case, this order in its entirety is before it. The appellate authority will have authority. You cannot say that the appellate authority will have limited role only in setting aside the order in original if the order in original of a particular type, unless the statute says so.
No, my lord, statute says any order, any decision. So, my lords, I am completely.
This decision of seizure is also a decision.
My lords, I bow down.
Which is appealable before the appellate authority.
My lords, this decision of Caesar, my lords, can't be appealed, my lords, with
Mr.
all respect.
Dhanuka, we'll have it next side. I
My
mean,
lords,
that
my
side of the
lords,
vacation,
my
I'll
lords,
also apply my mind.
my lords.
Prima facie, I'm not.
No problem, my lords. It is my duty to convince my lords.
Definitely,
Yes, my
definitely.
lords. Either I get convinced.
We are all learning from each
Yes,
other
yes, my
because
lord.
this subject is new to me
Yes, yes,
also,
my
as it is to you.
Yes, my lords.
So, I mean, as it is not to you. Heard. I'll come back in 5 minutes. I'll come.
But before your lordship calls on the list, you kind leave to mention a matter from the determination of his lordship Justice Hiranmaya Bhattacharya. He's not sitting today and tomorrow. But this is regarding extension of an interim order which is due to expire tomorrow.
Please give.
By the end of December, sorry.
Extension গুলো দিয়ে দেবেন।
But should I hand over a copy of the order as well?
You can hand up ফাইলগুলো আনিয়ে নেবেন, এগুলো এক্সটেনশন হয়ে যায়।
I'm grateful. But it will be taken up tomorrow.
Yes.
I'm grateful.
It will appear in the list.
Your Lordship, item number 11 to 16, these are analogous matters, Your Lordship. These matters were mentioned yesterday for upgradation after vacation, Your Lordship. However, it is
এগুলো
appearing
আজকে
in
চলে
today's
এসছে,
list,
দিদি।
Your Lordship. It was written. লিখেছিল। Your Lordship may kindly take up the matter in the first week of
এগুলো দিক
January.
থেকে ইয়ে করে মানে খোলার পর দিয়ে দিচ্ছি। 11 to 16 ইয়ে করে দিন।
Your Lordship has indicated a date.
I'll speak with the officers and then I'll arrange my list.
Grateful to Your Lordship.
Well, it's item number 17 at the outset, my lord. I apologize, my lord. I'd mentioned it, but my lord, certain instructions are required in the matter. My lord may keep it on the other side of vacation, my lord.
Item 17 এ একটা order record করুন। Learned advocate appearing for the affidavit of service টা নিয়ে নিন দিচ্ছেন।
My lord, we are challenging the notice under section 148 on the ground that it has been issued by the jurisdictional assessor.
This faceless.
Yes, my lord.
Who is appearing for the income tax authority? What to do? Okay, can anybody take instruction? Dismiss it. And not today করে রাখুন। Not today করে রাখুন, স্টে হবে আর কি। এই অ্যাফিডেভিট অফ সার্ভিসটা ফেরত দিন। নেক্সট।
My lord, item number 19, my lord, I'm challenging.
কি হলো দিদি দিন? কি হয়েছে? Passing it over, there is some problem with the file. পরেরটা কল করুন।
For 20, I'm for the petition. Here, my lord, I am challenging 148 AD order for the assessment year 17-18 on principally, my lord, 3-4 grounds. Number one, my lord, all notices order served in the old email ID. Though much prior to the proceedings, I upgraded the email ID as per provision of law. And my lord, secondly, my lord, of opportunity of personal hearing not given. Thirdly, my lord, while issuing show cause notice, gave 5 working days, and our division bench held that in the case of Girdhar Gopal Dalmia, that 7 working days. This main 3 grounds. And fourth is, my lord, the Jaufa issue and jurisdictional issue and faceless. But I have good merit of my case. If the matter may be remanded to the 148B stage, then I can submit my reply.
Yes, Mr. Bhattacharya.
Now, my lord, I believe from the submission of my connect friend, well, the department is very bad. Not send the notices in his old email. Now, my lord, the learned friend should say why the notice of April 2024, 8th
Yes.
April 2024 now has been challenged.
Yes, my lord. That is, my lord.
Now, after 8th April 2024, in the month of June 2025, the subsequent notices has been served on the faceless authority. Thereafter, the petitioner will wake up and file the petition. Now, it is settled principle of law, your lordship knows. The judgment, I'm very sorry, I could not bring the hard copy. From the Tridi Kumar Dingal and others versus State of West Bengal and others reported in 2009 1 SCC 768. But it is unclear term it says there is no upper limit of limitation in regard of writ petition. But it says the litigant should come in earliest opportunity. Now that he should come if the case of the petitioner is that the earlier email the notice has been served, he should come in the year of 2024, April 2024. Now that after the faceless authority take the initiation of the further notices, thereafter the petitioner come before your lordship court. And there is another judgment of Karnataka Power Corporation and another versus K. Thappan and another. It is also said, my lord, to exercise external jurisdiction if there is negligent or omission on the part of the applicant. The writ petition cannot invoke the discriminatory jurisdiction under Article 226. And
what is your explanation for delay, Mr. Rai?
There is no explanation in the writ petition.
Yes, my lord. The explanation at para 22 of the writ petition, my lord. Prior to that, para 21, that last notice of the department 133.6, that is also, my lord, old email ID.
Yes.
Thereafter, my lord, para
That's the
22
instruction.
on 27 June 20 received phone calls from the respondent number 3. Got knowledge that there is a 148 notice, such and such, such and such. Thereafter, my lord, filed that.
They have an explanation.
And prior to that, all national faceless also serve that old email ID. That is violation of the law.
Part, in that part, I have to take instruction because he has
Take
says
instructions. I'm keeping it after the vacation. Take
My-
instructions.
My Then, my lord, I have some submission. And also the all notices also after the order also, the national authorities, they have also served the whole email ID. Only after the telephone call that ever, my lord.
Yes.
I am grateful. 21, my lord, that can application, my lord, the lordship may remember that release of
Mr. Banerjee is appearing, my lord, in this matter, my lord. He requested me to pray for some time, my lord, at 2 p.m. or sometime after. Recess, my lord.
It's a small matter.
Small only for
a part was missed.
He is
actually.
not present, my lord.
When will he come?
After recess, my lord.
Very well. At 2 p.m.
Yes, my lord.
After
And
the fixed matter, I'll call.
yes, yes, I am waiting. And also, my lord, that order not complied. Till date, we have participated in inspection yesterday, but cash not desealed, my lord.
It was given to you to submit a representation within 7 days, and then they were, in our opinion, the applicant submission that is interest in the ongoing. The applicant will not be able to afford the first opportunity in same proceeding.
Lord,
appearing for the respondents. The OA by directing
Mr. Banerjee Junior is
Junior
engaged,
appearing.
he is appearing virtually, my lord.
for the competent authority within a period of 7 days. From the date of this you have
Ask
done.
Mr. Banerjee to come. This way it
And
is.
the respondents are directed
kindly
pass over the matter for 5 seconds if filed. In the light of
My
this,
lord, kindly take it after recess.
He's saying 5 minutes. Let him come. Why after recess?
disposal of
Pass
such
it over. If he comes, ask him to come.
Yes,
Passing it over. Ask him to come.
my lord.
22, my lord. Here, my lord, very small prayer, my lord, that we won against the 143(1) intimation. We filed appeal, though belatedly, but they admitted the appeal, issued notice of hearing, written submission submitted, reply submitted in September 2024. And in the meantime, my lord, my demand, though it is not payable, but I have annexed that in the all subsequent years refund, they recovered the entire amount. And also, their verbal direction, I have also paid, my lord, 1,26,000. So, my lord, my simple humble prayer, my lord, that appeal may be disposed within 1 month, and my lord, the refund for them, my lord, though not statutorily required, 20%, balance 80% may be refunded, my lord.
My lord, in this case, my lord, after more than 1 year, my lord, they have preferred an appeal. No stay application was filed. On that ground, my lord, the amount was recovered. There.
So that you make a play.
Yes.
This order I will not pass because there was no stay. You have
Yes,
preferred
yes,
appeal
yes,
later
yes,
on.
yes.
Then, my lord, remanded to the appellate authority
No,
direction.
you make an application.
Yes.
I will say you will make an application.
Yes, yes, that I will make.
Lord, will pass an order
No,
to the
my lord,
extent
I am not on that part. First part is, my lord, that appeal is pending.
Yes, that I am directing.
Yes.
Yes, yes.
Within 8 weeks, my lord.
The petitioner.
Appeal may be disposed of after
The
opportunity of
petitioner
Personal.
prays for expeditious disposal of an appeal pending before the appellate authority. Appeal against which order?
Against the 143(1) intimation, my lord, at page 43, my lord. This is not order, my lord. 140, but appeal level.
This
Page
is
43,
appealable
my
before whom? Before the CIT appeals?
Yes,
No.
my lord. Yes, yes, yes.
CIT appeals or ACIT?
No, CIT.
appeal.
And they admitted that.
An appeal
Well,
carried
page
against an
47.
order, carried against an intimation, carried against an intimation dated December 18, 2021, passed under section 143 within bracket 1 of the Income Tax Act, 1961. Full stop. It is submitted that although the said appeal was filed on
Appeal filed on, my lord, 2nd January 2023, page 47.
On January 2, 2023, the same is pending, still pending, full stop. Paragraph. In view of the nature of the relief prayed for, the appellate authority is directed to dispose of the petitioner's appeal as expeditiously as possible, preferably within a period of 8 weeks from the date of communication of this order, strictly in accordance with law. full stop, paragraph. It is submitted by Mr. Rai that the appellate authority, that the respondent revenue authorities may be directed to refund the sum adjusted by them,
Entire amount adjusted, subsequent years.
the amount adjusted by them from refunds of what? Refunds pertaining to which year?
My lord, at subsequent, my lord, I'm showing, my lord. Subsequent, my lord. Assessment year 2021, 2022, 2023, 2023, 4.
That sums.
Page 99.
That sums adjusted against refunds.
More than refund, more amount. Sorry, my lord.
Adjusted against refunds payable to the petitioner in respect of several assessment years. How can it be more than refund? There has to be some refund only
sorry,
then.
Sorry, my lord, more than demand. Sorry,
that-
I mistook that. More than. Sorry, my lord.
That sums in respect of several assessment years, such that the adjusted sum has exceeded the outstanding demand.
Yes.
In respect of assessment year?
Assessment year 2021.
2021-22.
22 and 2021, 2020, 21, 21, 22, 22, 23, 23, 24, 24, 25.
So 2021 to 2025.
Yes.
Say that.
Page number 99.
99.
Page 99.
99.
Within brackets, लिखेंगे.
My demand is 10.49 lakhs. They recovered 14 lakhs 63,000.
Very well. এবার লিখুন, having regard to the nature of the case, comma, no mandatory order can be passed on such request made by the petitioner, full stop. The petitioner shall be free to make appropriate representation before the appellate authority, and if such application is made, comma, the appellate authority shall consider the same in accordance with law.
But they have not.
Next.
But this is my lord. Last day, my lord, miss. Oh.
Number 21.
Where is Mr. Banerjee?
He's stuck, my lord. Lord, Mr. Banerjee was here. He has been stuck in another matter.
Tell me, you want to do it now or you want to at 2 p.m.?
As your lordship directs.
देखिए करे दी है. हाँ. Mr. Banerjee is not available.
Lord, he was here, my lord. He's in another court, my lord. That is
When will he be available again? He has vanished or he will come back?
He will come
So tell me that. When will he come back?
My lord, I have been informed that it may be taken up at 2 p.m. in that.
Say that unnecessarily. 2 p.m.
23, my lord. Last day, my lord, the prayed time for instruction, my lord. Where, my lord, the audit settled and the issue settled, taxes paid. Thereafter, issue so same fact, same year, same issue, my lord. And tax component only 35,000.
Yes, Mr. Bhattacharya, what are your instructions?
My instruction, the audit report is relating to the tax component only, and the so-called note issued for availment of access ITC for supply of exempted service. The two are different aspects. That's why so-called notice is proper, and your lordship knows as per notification 9,
of 2023, my lord, the time has been extended for issuing show cause notice that was extended to 31st December 2023. Therefore, show cause notice has been, my lord, issued within the time, my lord. There is no need for extension of time, my lord. Since the notification 9 has not been challenged in this petition, therefore the show cause notice is within the time, my lord.
Kindly,
that is my instruction, my lord.
kindly have a look, my lord, page 42, first allegation, my lord. Para 1, my lord.
Yes.
Para 1, inadmissible ITC taken and utilized, that in the column, my lord, that I have paid, and page 43, this is settled, and my lord, I am drawing lordship kind attention, show cause notice, page 45, middle portion. Para 1, my lord. Serial number 1. May I read, my lord? Non-reversal of the proportionate.
Yes.
Para 45, non-reversal of the proportionate able of ITC. So ITC issue, tax issue definitely, but that ITC issue already settled by audit.
Then
As
next
per
line, next line, my lord, due to supply of exempted goods and
that,
service.
that is different, but
This
inadmissible ITC.
Audit
This is
has been made on the basis of the
sir,
books and
kindly
records of the, my lord, assessee. And this was, my lord, subsequently it has been
Why are you
transferred.
not preferring appeal? You go before the appellate authority.
Yes, you can agitate everything there.
Why read court?
And also, my lord, he did not file reply, he did not attend the hearing, nothing.
But personal hearing not given.
Is there
And
order
in the, from the recital page
that he
46,
did
my
not-
lord, kindly have a look,
Kindly
page
come to-
46. Sir, আপনি বলুন না আমাকে বলতেন, আপনি সিনিয়র আমার।
আচ্ছা আপনি বলুন, আপনি বলুন।
Page 46.
46, my lord, first para, my lord, if no cause is shown against the action such and such, or within whichever is earlier, they do not appear before adjudication authority when the case is posted for personal hearing. My lord, record says no personal hearing notice issued, my lord. Nor is this date, time, venue mentioned.
Personal hearing notice was issued. My lord,
Not.
kindly seize, my lord, order in original. Kindly seize, my lord. Order in original, dear lord.
Page 51,
Page
operative
50 onwards, my lord. Kindly come to page 51, my lord.
middle portion.
First, my lord, reply to show cause come demand notice. The notice has not submitted any written reply against the said show cause. Then, my lord, on account of natural justice, opportunity of personal hearing had been given to the said noticee, but the said noticee neither attended the personal nor submitted any reply to defense.
Why are given, my lord? Kindly
They
show,
also
my lord.
did not
Why are the personal? I'm asking myself.
Adjournment whatsoever.
Mr. Bhattacharya, personal hearing, when was it given? Do you have any document to show
No, my
that
lord,
personal?
I don't, today, my lord, I don't have any document.
Record
Transfer, but one thing you lordship appreciate, my lord. First thing,
No,
my
where
lord,
record says that it was not given.
Not.
It shows that it is given.
No, my lord, it is
What
not
no?
given.
It is recorded here that it
No,
was given.
they are saying recorded, but notice not issued, my lord.
Well, what prevented him to file the reply? He didn't also file the reply to the so-called.
All-
Very well, even if he has not filed the reply,
But he is
doesn't mean that
entitled
he
to
not
get
given
hearing. My
personal
lord, my records, my lord, order shows, my lord, hearing has been given.
Show me then the copy of the
My
notice.
lord,
File a report in
my
the
lord,
form of an
only,
affidavit.
only one thing I'm telling you, lord, my lord, he can prefer the appeal also. Against that, he can agitate everything there.
Very well,
And-
but if personal hearing is not given, that is mandated by the statute. Why should he prefer appeal? Then the order is violative of principles of natural justice. On that ground, the order will go.
And also, I have also instruction on. I have got the instruction that person hearing was given. The
Was given?
document, yes. That has been instruction.
You file a report in the form of affidavit.
Or may I take instruction then come
back. Heard Mr. Rai, learned advocate appearing for the petitioner, and Mr. Bhattacharya, learned advocate
I'm getting.
Get to know. What is this matter? It appears to be very big.
Yes, my lords. My lords, I have come before the Honorable Court with three grievances, my lord. First of all, it is that my electronic credit ledger has been blocked under Rule 86A without giving me a personal hearing. Second grievance is that, my lords, notices have been issued under Rule 5618, which is not an empowering section for allowing for issuing a notice. And not only, my lord, once, but three such notices have been issued. My lord, if you may request my lord to go to page 24 of my writ petition.
Mr. Chakravarti, what are your instructions?
Well, blocking has been done. 5618 is for information. And we are asking him to give information. If he refuses, well, what can be done? And there is no provision for pre-decisional hearing in case of 86A. At least the provision does not say. We can give a subsequent hearing if he wants. Let him give a representation.
Yes, sir.
Let him give a representation. This matter cannot end here. This has a final order. There is nothing interim order. He doesn't want to attend the 50.
Why are you not attending the authorities?
No, my lord, we have attended. My lord, if my lord would see the paperwork that we have submitted, all these documents have been submitted, my lord, on 7th of August. My lord, 7th July, the search happens. 14th July, my electronic credit ledger of 67,41,663 CGST, an equivalent amount of 67 lakhs of SGS has been blocked, my lord, without giving me an opportunity. If my lord goes to page 138 and 140, my lord will see that even the reason for blocking, that is also different. There in page 140, they are saying that the reason for search, if I take my lord to page 140.
140.
Yes, my lord.
Yes.
My lord, first of all, I would like to also take later on, my lord, through 5618, which is not an empowering section for notice, and three such notices have been shared. As my learned senior is saying that it is for seeking information, but my lords, whatever information we are given, which is also evident from the paperwork, these all documents have been submitted. None of them have been considered as a
what we have 5618 says,
yes,
every registered person shall on demand produce the books of accounts which is required to maintain under the law for the time being in force. But if I ask a SSC to produce that document, if I've done anything wrong, this is first. Now, second is 86A. Kindly see Rule 86A. There is no decisional hearing. And this has been done. So he may give a
yes, where is your right of hearing before this?
My lords, just to counter the first thing that is my learned senior said about 5618. My lord, in the armor security judgment, in para 68, if I may read, my lords. My lord, should I share the armor security judgment?
ওই জাজমেন্টে একটু মোটা আর্মার যেটা বার করলাম আগে আচ্ছা থ্যাংক ইউ
My lords, in para 68,
yes,
my lord, it's clearly mentioned. An SSC may be held liable to pay tax along with interest pursuant an audit, scrutiny, or investigation. The liability can be discharged either through self-assessment or by way of assessment. Madam, sir, my lord, the next line. The Act contemplates the issuance of a show cause notice under section 73, 74, and 76 respectively. So, Rule 5618, which is a rule, cannot be a rule by which a notice can be issued. And if I also take my lord's...
Chakravarti, prima facie, I am also convinced because this is having evil consequences. You are stopping somebody, restraining somebody, or fettering somebody from utilizing his own money without passing an order. So and without hearing him. This
yes, well.
Then I come back after vacation and I'll argue this matter.
Argue this because this needs
but
to be.
My lord can always read down natural justice, but my lord, subject to correction. This is a 1 year thing. This is a time gap, time limited
Even
thing.
for 1 day or
Yes,
2
well,
days.
one day also, well, it's an
It's
but
an
I will
evil.
not argue something which is
It has civil and evil consequences
absolutely,
both.
my lord.
So-
Post-decisional hearing, my lord, those principles.
Post-decisional hearing will apply if the order is otherwise all right.
Yes, sir.
When we joined we used to say pre-decisional hearing cannot be replaced by post-decision when it enters civil consequences. Well, that was the wording we used to use always. But question is, well, the act, this particular rule does not provide, and this judgment paragraph shows me the show cause notice is only in respect of those provisions, no other provisions. My lord knows a statute and authority can do act according to the statute.
Right, that's right. That's right. But
my lord is saying this is adverse consequences. But come back after vacation. It will take some time.
Today is the fourth day, my lord. Learned friend, my lord, for instruction.
Learned friend on the previous occasion had shown page 180, saying that SMTT was issued. We were satisfied. But just the background, there were some difficulties. There were some issues to adjudicating orders. There was those matters. But this is where 180 is a date. My lord would find 9 June 2023. It is post adjudication order. It is not something during the contemporaneous period, but just show cause notice was dated. SMT 10 was 25th August 2022. His reply was 25th September 2022. The DRC 01A was 13th February 2023. His reply is February 2023. Show cause was 21st February 2023. And the adjudication, the first adjudication order is 29/5/2023. So it was by mistake it was done. 9 June, can you see the date? 9 June 2023. Wherein two adjudication orders were.
What was the problem here? Please come again.
Two adjudication orders were passed. And according to him, he was not given enough opportunity to for
So is it that matter where the only ASMT 10 or something was being attached with the.
Yes.
The detailed order was
No,
not
yes,
being
Malad,
attached.
he is right.
That matter.
Yes, Malad, he is
Yes,
right. Malad, we can because he has paid also. So voluntarily he has paid in between. Yes, so we can start from DRC 01 stage. I think that would serve all the purposes because this 180 was issued after the adjudication orders. Last adjudication was 5th June. 9 June, I have been told some glitches in the system. That's why it has come up. But
This
was
180 was issued after the.
adjudication, 2 adjudication orders.
After 2 adjudication orders, the reply was accepted.
Right. But this is SMT 11 stage. This could not have, but this is a kindly see SMT 12 stage. This was at the stage of scrutiny. But at that stage, there was no such satisfaction. That's why the show cause notice, pre-show cause notice, show cause notice, all followed up. So it was a technical glitch. If Malad wants us to file a report, it will delay. Malad would kindly set aside.
No, you file a report because this kind of jumbled facts. You file a report.
It will help my learned friend.
It will help me also if your report is there on record.
And Lordship may remember that I have last day, my lord, to assist your lordship, I have prepared one chart, my lord. Also last day submitted, but I am also.
Liquid. The respondent.
I'm getting.
All the parties are present. No, Zilla Parishad is the only party.
Respondent.
No, all the parties. Let us see. We'll reach. Don't hush and rush. Please wait. Let us see. We can reach. Yes.
But here is a matter for 2017, 2018, my lord. Well, in the return file for the month of February, my lord, a particular invoice was reflected. I am a works contractor. But subsequently, in the return file for the month of February, a RA bill was entered, my lord, or normal bill was entered. And before the normal bill, as because I'm a works contractor, my lordship knows that there is an RA bill and thereafter there is a final bill. Now, in that return for the month of February, the final bill was entered. But unfortunately, for the month of March, my lord, that final bill along with the March bill was again entered. They were twice entered. But it was rectified in 99C, my lord. 9 it was rectified. I had rectified it, my lord. Now, the assessing officer as well as the appellate officer, my lord, only depend without application of mine, my lord, they say, assessing officer says OIO, it says that the other party, I could not prove that the other party has taken the credit of my input, my lord. I've raised an invoice. There's a credit which is reflecting in the 2A, my lord. They have not availed the ITC. Now the appellate authority, before the appellate authority, I have produced all the documents to prove that that they have not availed the ITC, my lord. Now the appellate authority thereafter goes that there is a chartered accountant certificate which is required, which I did not produce, my lord. According to me, my lord, a chartered accountant certificate was produced, my lord. On the top, on the company's letterhead, the company made a declaration, and on the bottom, the chartered accountant certified that I have verified this book and account. My lord, now I'll take couple of minutes to, my lord, to take your lordship to that those documents, my lord. Page number 30, my lord.
Page 30.
30.
Yes.
My lord, 4A1 11786350. My lord. Hereafter, my lord, this is my turnover, my lord, taxable turnover. In page number 35, my lord. My lord, on the top, my lord, 3.1A. That same turnover reflects, my lord. This is 3A, my lord. My return. 3B. Sorry, my lord. 3B. Hereinafter, my lord, 337, my lord. Here I make the mistake, my lord. My total taxable turnover, my lord, in 4A2, my lord, 22857904, my lord. And hereinafter, my lord, 42, my lord.
Page 37, what are you showing?
My 37 is 482. Total taxable turnover, my lord, GST 1.
Yes.
My lord, here I make the mistake. My lord, 22857940. And my lord, in page number 42, my lord.
Yes.
I have corrected it. My lord, in 3.1A, my lord. 1.071374. If I wouldn't have corrected it, my lord, this figure in page number, my lord, 37, my lord, would have appeared over there, my lord. My lord, hereinafter, my lord, in page number, my lord, 44. But this figure 22857724, my lord, which is, my lord, lordship comes down to page number 37, my lord. 37 and takes 30, this 44 together, my lord.
Yes.
37 is the figure, my lord, whereof both the figures have been conjointly taken, my lord. My lord, if February and March. If one is deducted, my lord, the figure will match with the nine figure, my lord, in page number 44.
No, but you said this page 37 was a mistake.
It was a mistake, whereof one invoice pertaining to the previous period was also included in the turnover. If, my lord, other way, this 42 figure in 42 and, my lord, figure in
this 42 and 31.
31. No, not 31, my lord.
These figures are for which?
42, my lord, 35. Figure of 35 for February and 42 for March. If these two figures
are added,
it will be 9. But in page number 44.
Annual return.
Annual return. Well, I've corrected in the annual return. Now, lordship comes down to 76.
Here is 30, page 35,
35
plus
42. 42.
42.
Hereinafter, my lordship comes down to 76.
76.
My lord, 76. But 75, my lord, in fact. My lord, this is
75.
This is my recipient's ledger. My lord, I am take Ilya's stake, and on the top, my lord, GVS Projects Private Limited, that there is their ledger, my lord, and in their ledger, my lord, in page number 76. My lord, in fact, my lord, 75 is the only payment, my lord, received by me, my lord, made by them and received by me. And in page number 76, there are only records of 2 invoices, my lord, for the month of, from the top, 76, second, 28 to 18,
Yes.
11788, this is the first invoice for the month of February, and from the bottom, one line, line work, 1111071374, this is the second invoice.
31.3.
31.3.
Yes.
But this is the second invoice. Hereinafter, in page number 77,
Yes.
this is a certificate by GBS Projects Private Limited by contactee, whereof it says, that Mrs. GBS Project Private Limited, Vijayawada, further certifies that we have not received invoice bearing number RA2 dated this for rupees this, said to have been issued by Sheikh Ilyas this. We further certify that we have not paid the said amount of rupees this to Sheikh Ilyas, and that we have not availed ITC on the above invoice, though the same is reflected in the GS2A return for the month for March 8, 2018. Hereinafter, at the bottom, this certificate is issued for on the request of Sheikh Ilyas, this. Thereafter, the stamp and everything is of the
What
contact.
is wrong with the appellate order now?
I'll come. 1 minute, well, just. I certified the chartered accountant at the bottom, the chartered accountant is certified. Hereinafter, the lordship comes on to 110, the appellate order. 110 is the B factor of the case, it runs to 112. 112 is the ground of appeal. My copy paste of the ground appeal, it runs to 118. 118 is the order.
Yes.
Personal hearing, he appeared and personal hearing was given. I find that the 5.2. I find that the appellant has filed appeal. This was within the stipulated time period. 5.3. The appellant has contended that he has entered the same invoice firstly in GSTR 1 for February 18 and then again in March 18 by mistake, and thereby creating additional liability of 21,544. They stated that they have paid their duty liabilities in the month of February 18 through GSTR 3B of 21,575. But they have paid the said duty liabilities of GST 3B for the month of March, this excluding the liability on account of the above mentioned invoice. This was my submission. Hereinafter, 5.4 in page number 119. Is the copy paste of the provision of section 37. Lordship thereafter comes down to 120 page. From the bottom, Lordship will get 5.5. Before that, copy paste of the provision of law, section 37. Now, what is his opinion? I find that as per the provision of GST 1 could have been amended by the applicant and liability could have been extinguished. However, applicant has failed to do so. He is not considering my 9, the annual return. This is apparent that the applicant was well aware of the mistake and he did not pay this liability on account of 121, uploading the same tax invoice twice. Further, I do not find reason for such difference in GSTR 1 and 3B recorded in GSTR 9C. Hereinafter, 5.6, I find that the applicant sought 5 days to submit additional document with chartered accountant certificate by using this, but has failed to do so. I also find that case law submitted by the applicant was not squarely applicable.
Yes, Mr. Bhattacharya.
But what I submit, let me go back to the appellate authority. Let document be considered.
Chartered accountant certificate, if you still find that was a 2024 order passed in 2023. Adjudicated order in 2023. Kindly sees that 4.3. Kindly sees how the adjudicating authority comes to the conclusion. Kindly come to page 88.
Well, Lordship has told me to come down to directly to the appellate order. That was I skipped this one. Yes. I'll also submit.
Kindly come to page 88, 4.3.
4.3.
They stated that they have paid their duty liabilities in the month of February 2018 to GST 3 beyond rupees 21 lakhs and all. But
Mr. Bhattacharya and Mr. Choraria, this appears to take time. Can we have it after the vacation then?
Well, bank is attached, thereafter I leave it upon your Lordship.
Yes, Mr. Bhattacharya, tell me.
Now question is then
this is the same recording in the appellate order. Nothing new.
Today we are now end of the year 2025. My learned friends comes with the petition waited for a year. 24 September the order was passed, appellate order. What prevented him to come to this court had that been the case, my lord? There is no explanation as such why the delay has been caused. That is also another ground. Well, let him, let him, let him.
But I haven't waiting for the tribunal, my lord.
Only I am praying, my lord. Only I am praying, my lord. Let him secure certain amount, my lord, and my lord, we shall.
This is.
Not satisfied that the order is proper, because if it has not considered,
4.3, my
he
lord.
has paid his taxes. If he has paid his taxes, he.
No.
The
But
case
that
is
is
in the
not
return.
as my understanding saying, my lord.
If he has paid his taxes merely because he has uploaded the same invoice twice, he will have to pay tax again. That is the logic.
My lord, kindly see, my lord, then my lord, the other provisions are there for rectification. You lordship can appreciate. Suppose my lord taking my lord points which my lord friend is saying, well, wrong. My lord, he didn't take any scope.
Where is
there.
the chartered accountant certificate?
My lord, page number, my lord, I have again next to it, my lord, in page number 122.
It was of
My last page, my
2024,
lord.
Order original passed in 2023.
What prevented him to produce the certificate?
My lord,
This certificate is of 2025.
My lord, the previous certificate, my lord, this was from generated through UDIN, my lord. The previous certificate is in page number 77, my lord.
All are my lord, eligible copies have been served, my lord. Even
This
we
is
are-
also of 2024.
Before the appellate authority, my lord.
Oh, what prevented you to
Before the appellate authority?
No, why appellate authority? Why you don't produce the audit original?
But if he has produced before the appellate authority
My
should have
lord,
seen it.
my lord,
now my question is that adjudicating when the adjudication proceedings was given, my lord, that was subsequently, I think, my lord, it has been procured. If I am say so, my lord, subject to correction, my lord, because my lord, what prevented him to produce is before the my lord, adjudicating authority. In 2024, after filing appeal, he is coming to the.
But if he has now a certificate which he can produce before the appellate authority, should the appellate authority not consider that again?
23 ordinary original passed, 2024.
That is all dates. Somebody is having to shell out more than he is
Dear,
required.
my lord, in respect of chartered
No, this is not a case of fraud. This is
No,
not
this
that has not been-
regarding certificate.
that-
I am saying, my lord.
certificate. Now, suppose he gets the certificate later on and he shows the authority. Should the authority not consider that? Consider that way.
100.
You take instructions. Come back tomorrow.
Well, may come back with the instruction, my lord.
Tomorrow, come back.
Siliguri থেকে যাবে। Tomorrow.
Come back tomorrow.
I waited for years together, my lord. Kindly appreciate 23 and now 25. My lord, tomorrow, my lord, Siliguri.
No, his urgency is attachment of bank account.
You left it and wait for another one.
There is no explanation in the writ petition. Kindly see why delay has
Not required because of the
Tribunal is not over there. I am coming from the appellate authority's order, my lord.
waited for.
But tribunal is not functioning.
Where Mr. Choraria immediately after vacation, what is the problem? One more week.
I just at fault from this. My lord, one thing I'll mention, my lord. What has been said by him. My lord, why was the 9 return, my lord, which was in the portal was not considered, my lord?
Let us see, since we are running short of time. Heard Mr. Choraria, learned advocate, appearing for the petitioner.
I matter, my lord, I think the file is not over here, my lord. ঠিক আছে, আমি আছি. Let's approach.
27 yes.
Well, this is my application. Well, two issues are involved here. I have purchased scrap batteries from BSNL. One from Ranchi unit and one from Begusarai unit. But BSNL stored this sale in the next return, Your Lordship, in the next year's return.
Mr. Chakravarti, you are ready with instructions or will take time?
This would require, because a similar matter had taken place.
Had taken place
But
already.
difficulty is the BSNL makes the blunder. We also cannot utilize
Very well.
this, whatever. But this
Whatever
matters can move.
something
Yes,
which has
yes.
to wait,
Yes,
let us go because there are others waiting.
Yes, my lord. After
Well, again, notice is to be served upon them, my lord.
Yes. How will they know about the returnability?
Lord, item number 28, if your lordship kindly take after research because they have raised certain serious allegations. Now, Mr. Banerjee, I am led by Mr. Banerjee. You want to argue the matter. If your lordship kindly take
Let it be after the vacation then. लिखे नहीं as prayed for, list this matter.
Like 29, my lord, learned friend, my lord, supposed to submit instruction on instruction. That lordship may remember that natural justice violation both in adjudication and appeal, my lord.
but I have got instruction that applicant of this stage, he had got that he was given opportunity to appear. Which was for the last paragraph, which is marked slightly for attended apology.
Yes, appellate authority gave you time.
Yes, my lord. Appellate authority issued notice. I prayed time on September 2024. They issued the notice of adjournment in April. Thereafter, my lord, order passed in June. On that, not passed. So, ideally, my lord could have granted, my
So
lord.
what is the urgency now?
Then after vacation.
Yes, don't press for matters which are
Yes,
not
yes.
that urgent, so
Yes.
that others were
Yes, madam.
as suggested by the parties, suggested.
I'm grateful.
But I appear for the petitioner, my lord. As per my lord's last order dated 8th of December, I have served a copy on Tanay Chakraborty, my lord.
Yes, yes.
What is the challenge here?
My lord, I am challenging an order passed by an appellate authority dismissing my appeal on the ground of delay.
Delay?
Yes.
How many days delay?
Delay is more than 6 months, my lord.
6 months?
My lords.
What is the explanation?
My lords, it's a company established by National Highways Authority of India, special purpose vehicle company. A delay was due to change in management, my lords. That's
A company cannot say a change in management. Well, that is,
my lords,
let
the
him
main
come with a better.
no, my lords, the main reason is that the head office of the company is in Delhi. So it took some time to take approval from
It's a
Delhi office.
total-based,
Pay some costs. Pay some
yes.
cost as.
My lord, as minimal as my lords.
Yes. This writ petition assails an order dated Give
I
it,
have
give it.
also
Tomorrow
the
it will
matter
appear.
at number parting of today's list in report number 9. That's why I have mentioned your lot of speech back to mention at the matter appear tomorrow.
Tomorrow it will
I'm
appear.
handing
Give
over
the
this.
slip. Give
I'm
the
handing over
slip
this.
and send, give notice because
Sir, I will
if,
serve
if
notice,
both
sir.
parties are
Yes,
not there,
yes,
I'll not
yes,
hear.
yes.
Yes, Mr. Chakraborty. কোথায় গেল? I'll be sitting. I am not going. Don't worry. 2 p.m. Only one matter is fixed. After that, again, this list will go. After the fixed matter, I'll be taking up 2 p.m. Very well. Then we shall take it up.
Also, the group one matter which is appearing yesterday, the says portion number 19 is not, let it be included tomorrow,
Let it tomorrow. I don't know how many matters and what will happen. Give it. It will appear. I don't know what will.
Mr. Bhattacharya also mentioned
That I know, but yesterday I did not know that again I will have this determination today. It will be there in the list, but I don't know what will happen tomorrow. Nobody knows. I will also try my luck. Yes. Yes, Mr. Chakraborty. That matter.
But I saw it, well, the issue they have also raised in the application before the tribunal.
I will direct you to consider the representation. Say
The
whatever
writ
you have to
petition is not maintainable. I do not oppose this type of, the writ petition is not maintainable.
If an application, if a representation is made, you say that I will not consider it, I will consider it favorably. Whatever you have to say, you say.
Can you record that it is not maintainable? There are,
yes, I will record that.
Subject to whatever little, a mandamus will not lie where there is no.
I'm not asking you to pass a particular order, but I'm asking you to, somebody has made a representation. You will not consider that. You will not say whether.
Knowing fully well the issue is pending before Supreme Court.
You are not asked to decide what the Supreme Court is going to decide. You are not going to be the judge.
Whatever.
You will only dispose of the representation in accordance with law, whatever law says. That is, I am directing them to dispose of one way or the other. Call করে দিন তো শেষ করে দিন।
But only record my submission is not.
I'll record that it is not maintainable.
But there's some instruction. That's why I want. Or else, I do not push.
এটা কি দিলেন? এটা নয়। না না। আরে বাবা, যে ম্যাটারটা কল হয়েছে সেটা দিন।
41 হচ্ছে 27835 27835। Just one page. It's my duty. That's why page 310. I'm tender unconditional apology.
No.
310. His application before the tribunal, and kindly see page 314, page 5, first 5 lines.
310.
310. His application before the tribunal. Thereafter, 314. The relevant paragraph.
314.
Yes. Kindly after first 5 lines. Your petitioner also contained that your petitioner's manufacturing unit is situated in Falta Special Economic Zone in the district. Your petitioner imports a goods.
Where I read it?
After 5 lines.
Yes,
your petitioner also contains that your petitioner's manufacturing unit is situated in Falta Special Economic Zone in the district of South Chobbish Purgana. Your petitioner imports the goods from outside the way and directly sends the said goods to its manufacturer.
Yes, sir. This was a point taken by you.
That the entire pattern of the judgment except was not decided. That is the reason I am before the.
But then, Mr. You have made a representation only for the purpose of seeking as to whether you fall within that category or not, no longer remain in the zone of confusion. No, if see, Mr. Shastri, the law is also that if something has been said, prayed for, and nothing is spelled out on it, and it has not been answered positively, then it should be treated as having been rejected. That is the principle. Very well. They have that is a point of contention. No, there is an adjudication in the sense that they have not granted you this relief. I understand that it has not been expressly negated. But by implication, it has been negated.
No. The only issue which was considered for all these judgments is that whether the entry tax levy, the issue whether SEZ, the constitutionality of the entry tax.
I will keep it open to them to say the same thing that he is submitting on the representation. Because
I
I
have not
cannot
gone into the merits of the because
I will not go.
because this
I
will
don't
give
have
another
authority.
cause of action. This will give another this issue. No,
Having my representation October, let them decide it by this week so that at least I have a right.
this week
Whatever.
this week it not be possible. 5 days working days. No, the issue is where they
I'll say as expeditiously as possible.
Yes,
Now,
sir.
whatever it means, because this writ petition seeks issuance of a writ of mandamus commanding the respondents to consider the petitioner's representation dated October 13, 2025 and to issue
last week. Solar.
I have a manufacturing unit and a special economic.
Yes, solar.
No, no,
এখন আর
relief
বলবো না,
was
charge উঠে যাবে
taken
already.
to the tribunal. The next page is that
একটা আছে,
declared
কালকে
its
last
right to entertain ultra vires.
uh, 31st is the last date for apply, my lord. I have already 3 times mentioned, my lord, for my lord, I'll apply under SOD scheme. 31st is the last date. I have already mentioned, my lord, 3 times. 3 times I have mentioned, my lord. No, no, listing, my lord, paying for listing, my lord. Paying for listing. Petition. My. There's a petitioner. তিন দিন হয়ে গেল কালকেও আপনাকে বলে গেলাম কালকেই লাস্ট ডেট তারপর পাবো না 31st লাস্ট ডেট ফর অ্যাপ্লাই
Yes.
Within the spot one, I have the carriage of
He is the petitioner. Let me hear from him. You will get the chance to rebut.
So I take you lots on order first. One is 2004.
Mr. Banerjee, please don't go away. There is an application short. We'll finish it. Yes. Because that part has not gone in the order. It was dictated. Yes.
Kindly take up your losses. There are two orders first. The first one you lost to find that pay
130.
Then I will take
130.
This is order dated 11th April 2007. So can you see the facts of the case? The problem is admission of girls students in Goura Sonamui KPS Kanyam. Though there is a girls school named Sonamui Chirodamam Alpha, the people of the locality have a tendency to admit their girls in Goura Sonamui KPS Kanyam. The girls' school is confronted with the existence of crisis because of the third decline in raw strength, whereas the co-education boys' school within 100 meters of the girls' school has registered abnormal growth in respect of the admission of the girls' school. Well, these are the facts, admitted facts. Because I will develop my submission from this. As per direction of the Honorable High Court, the hearing was taken by the administrator of the board on 8 April 2014. The West Bengal Board of Secondary Education directed the boys school not to continue co-education in violation of this office earlier direction given by memo number such and such dated 2nd September 2004. If the boys school still ventures to continue education, this office will be left with no option but to take stern view in the matter. Being agreed with this decision of the board, some guardians have filed the instant writ petition, claiming that they are interested in admitting their words. In admitting their words.
In such an institution.
Such an institution which has a good reputation, but to the directive of the board, they are unable to admit their girls from classes 5 to 8 in Goura Sonamui KBS Mekhala. On 23rd December 2017, the Honorable Mr. Justice Rajiv Sharma directed the concerned authority to dispose of the representation dated 11th November 2016 after giving hearing to all the interested parties within 3 months from the date of communication of the order. In the same representation, the guardians have expressed their eagerness to admit their girls in the co-education. Accordingly, hearing was fixed by the president of the board on such and such date, notice of hearing issued. On the scheduled date, the following persons were heard. After thorough scrutiny of the relevant documents, taking into account the submissions made at the time of hearing, it is revealed that the total roll strength of the girls' school is around 200. The school has been converted to a sponsored institution on 2015. But what is strange is that Goura Sonamukhi KBA Adarsh Shikha Nasathon has admitted 33 girls in the year 2015, violating the order dated 6 January 2015 passed by the Honorable High Court and also the directive issued by the court by memo dated 15 July 2024. But I will take your lordship to both the office. The HM of the co-education institution has himself admitted this fact at the hearing. This is present. There is at present 52 girls
in class 11, class 10, and 53 girls school in class 9. In view of the above, I proceeded to dispose of the representation by upholding the earlier decision of 15 July 2014. And the authority Board of Sonamukhi is warned once again not to admit any more girls in the secondary level in violation of the directive that will invite stern proof. I do not find any reason, though facts are required. Now, your loss is to find out the reason skipping. Your loss has to go to 5th July 2014 order. But I just take your loss to the 5th July 2014 order. The 5th July 2014 order, your loss is to be getting. Page 8. May I place it to your that's backdrop of the Sonamukhi Tirozamai Balika Vidyalaya was recognized as a 4th class junior high school with effect from 1st January 1986. The managing committee of the school unanimously adopted the resolution in its meeting dated 1988 with requesting the board to withdraw the co-education permission from classes 5 to 8 of Gora Sonamukhi Adarsha Shiksha, which is situated within 100 meters of the same girls. Therefore, one school is asking for, that's a girls' school, asking for co-education recognition or permission of another school. On the plea, this is within 100 meters. The government order or the board circular cited of 1955. So we have to take our list ourselves to that archaic medieval age to see whether the co-education school can run within 100 kilometers of a girls' school, if on competitive level. And if the girls' parents wants that their girls should get admitted in co-education school on merit basis, can it be prevented? And such prevention amounts to violation of right to education. That's the point. The second point, even if I take your losses to the board's own circular, that doesn't stand in the book. I will show you that. Even in 1955. This is the crux of the matter. Not admittedly, I tell your losses because the tax time is short, because I have to get myself admitted in. But this school was established co-education for at least 10 to 15 years before this girls' school. But in the radius of this block, there are 8 schools at least. But your losses certainly may put a question, why are you asking for this school only? But this school has all the modern facilities. But suppose my girl can secure her admission on merit, why he should be deprived? But co-education is not negativated by the authority. It will be against the constitution in 2024-25, standing in the way. Now this stand has been taken, they prayed for girls because of this, they cannot get students. And they are survival at stake. But is it a ground? And board is accepting in the 2020 decade. If you cannot survive, that's your
this writ petition assails disorder.
What they will take that the earlier writ petition was disposed of, this is other time. But I am, my lord, agreed by this order when I want to get my daughters being admitted. The earlier writ petition pending because of lapse of time that has become impossible. Because they had to get their students admitted in another school. They were sent up from that school. They are passed out. Now I have to suffer the same fate. That's why I'm chasing for your lawsuit. Kindly get it done. Why I tell you lawsuit? All the modern infrastructure, even my lord, I do not find in the district schools so much of computer advancement. So why my daughters will be deprived of those education? This is the only point. I take your losses to be factual. I will give you the others. And it's the board's circular on this basis this was done. I take your losses to that. 61. I take this. So kindly come to page 61. On this basis, they passed this order. Initial order of 2004. I don't know about the page 61.
1953 circular.
53 in the bottom of law. 16 July 1956.
The second one.
The attention of the authorities of the secondary school in West Bengal is drawn to the following direction in connection with girls' education in the state. The Board of Secondary Education West Bengal has not accepted the principle of co-education as such in schools. Girl students are not admitted in boys school and vice versa as general. All therefore, 60-70 years before, just immediately after independence. Can it be a law, my lord? The Girls Student Board did not encourage broader like girls. All the schools are, my lord, co-education now. All of our child gets education from the court. That is healthier. Now that is healthier, but I am not uttering what is the education is now being done. Because for empowerment of the students, not only with the girls, but also the boys. How do they deal with the girls, and the girls how to deal with the boys? And we are taking the medieval age. You know, girl students can be admitted in boys school, in co-education school, have been granted permission. Now you're asking when can this be brought? Only in exceptional circumstances, the board grants permission for admission of a limited number of girl students, subject to the following conditions being fulfilled as laid down in board circular number 48 by 55, dated 17 September 1955. But admittedly, the boys' school was granted permission to admit girls' students. When this was done, these girls' schools were never established. This was subsequently established. Why I am hopping this, I will show from this circular. Then your lordships will find these are the conditions. Your lordships. Then your losses can come to the next page. Those are not relevant except clause 5 of the next page. Roman 5. The permission for admission of girls in any class shall not be given when there are girls' schools in the neighborhood within a radius of 1 mile in a city or town, or within 2 miles of a school situated in a rural area. And also if such girls' schools in the neighborhood are in a position to admit the additional number. What I am on, first I am questioning this correctness of this in the angle of constitutional man, whether this can survive. Even that you know, hold it, I will go to the point subsequently. Even you hold that, can it be applied in the present fact? Permission shall not be given. Permission to the boys' school was given for co-education before that establishment of girls' school. How can you withdraw that? I'm asking myself by applying this permission. Just because girls' schools you have brought in within 100 meters subsequently, does it apply? The existence of the girls' schools must be there. Then you cannot. Kindly look at it. The permission for admission of girls' schools in any class shall not be given where there are girls' schools in the neighborhood. So the existence
permission sought for will be subsequent to the existence of the.
Exactly, how can you withdraw? This is one aspect. The second aspect you'll also kind of look at it. Now I find being a parent of a girl that there are two schools side by side. One school girls and one co-ed. I find that the co-ed school have better amenities for education. Would your lordship prevent me from getting my girl admitted in that because of this? You have permitted it and admitted me also. My answer to this, your lordship, you cannot, this is unconstitutional. Second, your lordship, board has taken a admission, the girls' schools do not get girls' schools. So it's ridiculous. Then this whole your parameter of education is not good. That's why parents are not sending their students towards your school. Can you restrict my choice that I will get my daughter done? If the resultant effect is that your school doesn't have students, it is the duty of the board to withdraw the recognition of the school, not to grant permission to the others. You want to save a bad school, you are withdrawing the permission of other schools. This is in short, this is the matter. Now I take you the very short matter is being painted. Just no. Kindly look at this, page 63.
Page 63.
It's a very next.
Yes.
But these probably my words were didn't even want you also when this order was issued. You were requested to take steps into discontinue co-education from classes 5 to 8 in your school right from this academic session, as the permission of the same has long been withdrawn by school. Well, when it was withdrawn? It was withdrawn, your lordship, few years back. Now since then, one after another, this petition has been moved. What happened, your lordship, to petitions? Because the parent students passed out from where they got admission, they lost their interest. Now ultimately this went up to the division bench. Division bench passed an order because of this, that you cannot admit all that violating admission. The board should revisit your stand. That's the perfect situation.
Where is that order?
That order, just Dr. Order, page 64. That will first your lordship. No, I just first page 69. What was the other order issued your lordship in respect of
69.
earlier? Then I will take you as
Page 69.
your lordship will find that questioning this order 20 4, there was a repetition. Initially, Justice Indira Gandhi granted a stay. Then, my lord, continued admission. Ultimately, the matter was dismissed for reform. Then, probably this was restored, and then an order was passed. Ultimately, your lordship, kindly have a look at the page. And in another repetition, your lordship will find. Now, dismissed for reform. Then another petition was done. So can you look at page 78?
78. Yes.
So it was moved by the girls' school. Stated by Mr. Mukherjee, Learned Council appearing that he has filed the Bafala. The petitioners give us, this is girls moved by the girls' school, that in spite of an order dated 22nd September 2004, which was challenged in the earlier petition, initially got stayed but dismissed for default. Passed by the board, directing the concerned request for the school having to discontinue the co-education from classes 5 to classes 8. The school in question is running co-education in the classes between 5 to 8. It is not in dispute that the order dated 2nd September 2004 has been stayed by this court in such and such by order dated 2nd December 2004. It is also not in dispute that the writ petitioner's prayer for addition of party in WP number such and such was rejected. The petitioner is now seeking to take a chance by independent writ petition, praying for implementation order of the 2nd September 2004 in a most crafty manner. Girls school, this writ therefore dismissed with cost of 2,000 years of the same 1,000 to be paid to the respondent number 5 and the other. They attempted to get an order, but ultimately board is in their favor. They will also find this impugned order was filed at page 8. I place it before the lawsuit now. I place just now the lawsuit record. The court says that since 2004 orders are high, you move the writ petition someone, but ultimately dismissed for default, you cannot get it. Because if you technically you will have to ask me, certainly that's the right, because dismissal of the writ petition But when they wanted to implement this order, court rejected it. Now you are also, but the board imposes it upon the board. Now you are also to find this matter when the again you are also before this order. You are also can look at page 98. This petition questioning that page 82 order, 27 June 2014 order, the administrator of the board. Skip over the first paragraph, second paragraph. The daughters of the petitioners are students of the said card. According to them, the order of the administrator is enforced. They are daughters who have to discontinue their studies in the said card and compelled to take admission in any other nearby school, which is not to their liking. Then your lordship, entire arguments have been noted, and then your lordship should find that the point of doctor, your lordship, last paragraph, last but two paragraphs. But or your lordship, 100 paragraph, page number let me place it to I need not examine the controversy as to whether board is justified in discontinuing the co-education facility in card. Therefore, the court is not entering into this, since a decision to that effect has been taken more than a decade. However, having regard to the fact that such order was challenged before this court, and such challenge in effect has failed by reason of dismissal for default, I am of the further view the interest of justice to be best served if the equities are balanced, and this petition is disposed of at this stage by issuing necessary direction. I direct the girls students who have already acted, or they were directed to continue to their act. Last paragraph. It is made abundantly clear that notwithstanding the arrangement to be worked out by this order, the board shall be at liberty in the interest of the education of the students of the locality to take any further decision that might be necessary, including review of the decision as communicated by me. Because the court could not swallow it, but because of technicality, I questioned it, some guardians questioned it, but got stay order, but ultimately dismissed for default. So that's why court could not enter it. So this is still open to me, because I am a student of now. You cannot show me the 2004 order, because my girls have become now eligible to be admitted. So this is, my lord, according to those court circular, is absolutely unconstitutional. These are the facts here. I am not taking, my lord, within a radius of 1 kilometer, 8 schools are there. Let me place people of this judgment, then I will take you off. Just I need underline the highlighted portion kindly. I want to see 1992 SCC online, Allahabad 809. But as far as my knowledge goes, Justice Kartu was always spoken. I should not want to go to that extent recently in respect of all of the Supreme Court judges' remarks while hearing a matter. Justice Kartu again is the but kindly see the logic of this guy. He's a very erudite person. There is a boy institution called Allahabad Intermediate Law. A copy name of this name, which is a recognizable institution under the UP Intermediate Education Act. The institution was started in 1910 and has throughout been a boys. The allegation of the writ petition is that for the session 92-93, the committee of the management is going to admit girls students, and it is alleged that this is a violation of regulation 8.1 of chapter 7 of the UP Intermediate Education Regulations, which states girls shall not be admitted into boys' institutions without obtaining prior approval of the inspector. By means of this petition, the petitioners who claim to be students of this institution have prayed for a direction to the committee of the management of the institution that it be restrained from admitting girls. I have heard Mr. Satish Chaturvedi, learned counsel for the petitioners and learned counsel for the respondents, and urge that prior approval of the disciplinary script of schools has not been taken before admitting girls to this in 1990. I had passed an order granting 2 weeks time to the standing council to file affidavit. In my opinion, Regulation 8 of Chapter 7 of the regulations is arbitrary and violative of Article 14 of the Constitution. Now, Honorable Judge gives us. In my opinion, educational institutions segregated on the basis of sex are a sign of backwardness. And the sooner this segregation is done, with the better for the country. It is my firm belief that all educational institutions at all levels should be co-educational. Co-education is healthy and good for the development of the personalities for both boys and girls. If there is co-education, boys and girls will know how to interact with each other in a healthy manner, and that will also help them towards social adjustability. In sexually segregated schools of the thought college, boys and girls live in inhibited environment with false notions and fantasies about their opposite sex. Co-education will make children more mature and more realistic. Now there is a subject you lost in this presentation. Sexual education is a subject now. Now a lot of giftism and other such harassment will stop if there is co-education. Even rowdy boys are likely to improve in a co-educational institution since they may not wish to incur the social disapproval of the young ladies of their class. Similarly, girls will get to know the nature of young men better and will learn to interact with them in a healthy manner. At present, the situation most places is the young men and women who have studied in segregated institutions till the age of majority are elder and often dumbfounded, tongue-tied in each other's presence. A young man does not know how to interact with a young lady and behave in her presence. And the young lady is terror-stricken in the presence of a young man, as he has only interacted with her father and mother in bed. This segregation leads to several kinds of psychological and social problems, and hence it should be unavailing. In fact, all modern countries have co-education. Article 39A of the Constitution states that states shall in particular direct its policy towards securing that children are given opportunities and facilities to develop in a healthy manner. In my opinion, development in a healthy manner for children is best possible in co-education. The right to education in Articles 41 and 55 must be construed consistently with Article 39A. In a proper entitled psychological perspective on adolescence and the rationale for co-education, Mrs. Camila Thapa, lecturer in the psychology department in the Allahabad University, has said, it would be tenable to argue that the co-educational system, as opposed to same-sex schools, would provide an opportunity for adolescents to interact with the same gender as well as opposite gender peer groups. These would prepare the ground for healthier, more open interaction between the sexes and to promote healthy attitudes towards the issue of sexuality. And co-education offers a first-hand opportunity to observe the behavior patterns of other adolescents of the same and opposite gender. The advantages actually would be twofold. Number one, the adolescent would be able to sustain and refine his or her personality and identity. Two, sex role identity would be more clear articulate and the problems sexually will critical and significant issues at this juncture, as well as the future will be to be influenced by experiences in co-educational system. It is hoped that as this system enables a peer interaction between two sexes, the adolescents would not always mean to a sharing, viewing out of the fantasy of intimacy and the landscape whose countries contours are shaped by more obscure desires and fears men and women entertain in relation to each other. Calcutta's report was 1989. In view of the above and clearly of the opinion that regulation 8 of the chapter 7 of the internet arbitrary and violative of Article 4. Hence, it is not necessary for the committee of the management to take prior approval of the districtness before admitting those. The rate petition therefore fails. Probably the Mr. Bolwa stands to give because it was the worst. Don't agree. Student, girls school, they are opposing. But it's against the Article 14, it's against Article 19, it's against Article 2021 or 2021. A right to life includes right to education now. So no address is necessary to law. My right to education you cannot prevent. You may not entertain your girls with co-education. But how do you prevent that on the basis of sex? This is absolutely unconstitutional of 1954. Lord, kindly take up this report. I will hand up this copy to my brother. Towards equal. But I will just take your lordship. The year of 1974. Board is relying upon 1956 circular. Now this is 1974. What happened in the minds of the government? Kindly have a look at co-education 6.65. Chapter you will page 272. Now your lordship, I will take your lordship to page 274, paragraph 6.7. Now this is 74. Now there are 2025. Almost 50 years and over. Finally, paragraph 6.7. In our opinion, the considerations of efficiency, economy, as well as equal opportunity require the acceptance of co-education as a long-term policy. In view of the divergent social attitudes, however, we recommend co-education should be adopted as the general policy at the primary level. 2. At the middle and secondary stages, separate school may be provided in areas where there is a great demand for them. Now I will address on this. But the effort to pursue co-education as a general policy at these stages to continue side by side. Pause here for a moment. General policy co-education, even from primary, secondary level also that. Kindly see the second says, my lord, middle and secondary stages separate school may be provided in areas where there is a great demand. Now that I am standing the co-education commission form before the establishment of the girls' school. So, how could you apply this policy? You can establish separate schools. That doesn't mean on their prayer, girls' students' prayer, court will record the permission. These are totally against the constitution. I am clear to you what I am submitting. If you demand their girls' schools, establish it. But you cannot prevent a co-education permitted school to stop admit the girls' school. You cannot do that. But this is the entire matter. They will jump up to the 2004 decision and post because I am affected today. Time doesn't stand in my way. So these are only one thing. Probably this will be the last
step.
Probably this month will be the last day for admission.
Let us see when it is.
I'll let them know. That's an interesting. But may I take your short leave? My junior will be here. I think my submissions for whatever they submit, this will be my decision. This is against the constitution. 2nd January is the last date for it.
2nd January on the reopening date.
If your lawsuit wants to decide it on very consider judgment, kindly allow them to fill up the form, subject to independence. But I just take your lawsuit, this I will come back with another matter.
It's all agree, and we have seen that society reflects something else. There are very much unwanted incidents happening in all political schools. Logic also the feeling of the number logic is that petition matter. I don't know whether the rule is under check, but here they are not challenging the rule. The notification of 6 is not under challenge. I don't know whether it was under challenge or not. Number one. Number two, the logic when you come to page 100.
It was not under challenge.
Yes.
Here also it was not under challenge. No, the submission of Mr. Sanyal as regards the notification or the circular, whatever we call it, is that the circular also, if read in a particular way, would indicate that it is only then that the otherwise thing will happen. If there is a co-educational school which is existing prior to the existence of the girls' school, then the permission may or may not be granted. That is the language. So 2nd of January is the last date of filling it.
Yeah, this should not be read by the other
Page 100.
Yes.
Yes.
Here read the second. Guiding the girl students who have already been admitted to the said Shikha shall continue to pursue their studies till such time their parents and guardians wish them to do so. Or other examination and the decision of the board conveyed by memo dated 2nd September 2004 and memo dated 15th July 2014. Enclosing copy of the issuing order of the administration shall not have any effect so far as are concerned only to those students in 2015 we were studying. However, the authorities of the said Shikha shall not admit any new girl students in any class henceforth. Well, this order is not appealed. So this order remains. They have not challenged this order. So there is an order of the Honorable Court which said that the school is prevented from admitting any part of students in the said school. Not challenged. Now I think, but they have challenged it.
No, but thereafter they were given liberty again in the interest of the education of the students of the locality to take further decision, including review. Now they have taken that decision. They have gone a step further. Now, if they have taken a decision and that decision is operating harshly on them, then they are entitled to challenge that decision. Everything becomes open again then.
On maintenance point of the litigation. Why? This is not a public interest litigation. Who are the petitioners? The petitioners are students, are guardians,
Because they want their wards to be admitted in that school. No. They say they have disclosed who they are in paragraph 2.
The number one given in class 12. And can you see?
Yes.
In class 4. In class 12.
Their grievance is that they want their wards to be at their. Why not? If this school is only till class 8, it's not beyond 8. Then
My lord, see, lordship will find in every order of the board that not to admit girls, even in the order of the
It was not till class 12 when it was filed. In 2024, it was not till class 12. Order of? Yes. That is of 2015. The order is of 2015. The writ petition is of 2024. Yes. Yes.
Because I filed over content applications before justice before that. And now your students the content product that 110. They clearly paid 110. I filed a content application. Can number such as the application for modification clarification. And the application for the area and the respondent accordingly a plain reading of the order data 6125 would be not in doubt that the
No, Mr. Barua. Page 112. Second line. There was no restriction insofar as admission of girl students in class 9 to 12.
there is no restriction.
So therefore, the school was till class 12. The school was till class 12. It's not till class 8. That is a different thing. Now, if somebody wants to get admitted in a particular school by no, but the court, if the court finds that this decision has to be in the interest of these students, if this court finds that it is not in the interest of these students, then in that case definitely court can intervene. On the ground of it being a policy decision, arbitrariness cannot be allowed to go, because yes.
The order clearly stated that the admission in class 9 to 12 was not in the petition. He was paid for clarification of the portion of the then we was trying to next page in view of that I directly admission. You also get page 112. Back up page. In view of I directly admission done to the student would be regularized and the board shall treat them to be duly admitted as students of the said Shikha. However, it is made clear that with effect from the
Very well, that the admissions are till second. Till second they are open. I'm keeping it as the first matter on second. I'll finish it off and that. Why? The court is open because it's a matter. Ask somebody to be there. You have made your submissions. Because if the school, the admission itself is going to stop on second. No. If the admission is closed, seats are filled up, what will happen? Yes. They want it to be in that school only. That is the point. There has to be seat. Forms have to be filled up. If that exercise is not then, then I'll have to extend the time. I'll have to extend the time for the purpose of it. Second is the date when the admission is closing. So that is the date. That is the admission. Please take proper instructions.
every school open on fifth. Admission form has been given out, my lord. Again, my lord, they accept the form.
If your lordship decides, your lordship already can extend the time, my lord.
The school is a party here.
Yes. 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 Yes.
But you are not available on second. That is the problem. If everybody was available. No, madam. That will create problems. That is the last date. They are saying that you have also not contradicted that. So guardian only is the petitioner. Guardian is the petitioner. I'll have to believe the petitioner. Why not? They are minor children. Minor children itself. No, madam. These are all technical points. I will immediately. I can immediately. Scotch them off. Not required. A minor will always have to be represented by the guardian only. How can the minor file a writ petition? Then why are you saying that? Why? Yes, because different schools, they want their what to be admitted in a particular school, which is not being able to get them admitted because of the board circular. That is the point. That is the whole thing that was argued just now. Not required to be challenged. If the circular says, if you read this, not required. I am not going to strike down the circular. But if the circular also is properly interpreted, since the girls' school or the co-ed school existed prior to the girls' school, the prima facie reading of the circular shows. Yes, but your girls' school came subsequent to the co-ed school. Then I'm extending the time for admission. Yes, I'm extending the time for admission so that they'll take the forms till 5th or 6th, whatever. When will you be able to come? Your affidavit? But extending the time will be intruding into the management of the school now. That is one other problem. Then, madam, you make arrangements for second. I'm fixing it on second. Somebody will be there. Ask somebody to be there, because it's getting difficult this way. Since 2024, this is pending. No. 5th, the school is not there. School's admission will close. I'll keep it as the first matter on second. Very well. If the form itself is being accepted on second, acceptance of form is closed on second, then I'll have it on second. And so therefore I'm fixing it on second at 10:30 in the morning. I'll ask the forms to be filled up if I am satisfied. 5th is not possible, madam. No. Madam, make some arrangements, or you make your submissions today. Madam, it becomes difficult because that is the last day. Kindly appreciate that. Ask somebody to be there. Very well. On that day, I'll and the school is not here. Please ask the school to be here. If I extend the time, school has to be here. Please serve the school. But since it was upgraded, they might not have got notice. Ask them to be there. He'll be there on second. Ensure his appearance on second. Then how will I pass the order? Extending time. But without hearing the school, how can I do that? The school is required to be heard for that. No, but it has been upgraded. It becomes last day. Similar situation. Even then. Please take proper instructions. I also doubt how can second be the last day for acceptance. Second is the reopening day. It can be 1 or 2 days even thereafter. Very well. I am keeping it tomorrow at 10:30. You take proper instructions and come. Tomorrow at 10:30. If I extend, I'll extend. 18 ছিল একটা, না না আর জগদা ছিল তো 18টা দিন মেনশন করলো না। What is the order? I don't know. Oh, it's DOFO matter.
Other point is there on immigration from the previous more than 6 years. And information they are like
the Who is appearing for the respondent? You are appearing. I will relegate you to the appellate forum. Take these points. Delay, how much? How many days delay? And how you explained? Very well. This
would change the entire circumstances of the document. Which can, which thing. Yes, good, and I'm grateful to him. So this is the first time you're not someone has. But it clarifies the question. Which orders will be in the main tab and which orders will be direct.
So in this case,
This no cause notice was on 23. So at that time, this
he didn't have the notice.
So I'm not challenging in this matter. With other matters, it might be.
Very.
Okay.
21, 31.
21. Can, my lord, that partial modification, my lord, para 5 of the can application, my lord, that cash seizure matter on this.
21 na 31 too.
21.
21.
21, my lord.
Yes, Mr. I'm incorporating that. We'll make a representation and you will consider it.
Because if it is required, any books and documents are there, that will be required. If any is taken or without any purposes, then it should be.
And para 5, I had not mentioned that you will approach the petitioners with bond and all. I did not say that. This kind of drafting is.
No, I apologize for that. Yes. As person. I apologize for that. Yes, it's my mistake.
It's peculiar drafting. You should take instructions from your seniors before you draft.
Yes. I apologize.
You withdraw this and file again. This kind of an application should not be filed.
Yes, it is my mistake. My mistake.
Two. The next matter is, my lord, a very short matter. It is, my lord,
HON'BLE
the
list.
condonation of delay, my lord, of 26 days, my lord. Kindly take.
Who is appearing for the respondent?
Mr. Shanal is appearing, my lord. My lord, before the vacation, my lord, we all are in a hurry, my lord. And my lord, pressurizing.
But this matter could have waited for after the vacation.
And my lord,
delay condonation, this can wait till after the vacation.
I know, my lord, the only 26 days delay. Yeah, if I leave it to your lord.
Even after vacation, it will remain 26 days. It will not
know.
become 50.
I
Because
know.
there are other matters which are waiting for.
I leave it to your lordship. I have a bank attachment, my lord. I have a bank attachment at page 44A. Bank attachment at page 44A. Delay condonation. If appeal me restored, my bank attachment, are you already paid, my lord, that?
Listen.
Not the pressure to take up original side.
Original side is yes. Original side.
But in the appellation, the item number 33, 36, and 37.
What happened to that?
Can it be written in the list in the same?
It is there in the list.
It can be written in the list tomorrow in the same position.
Yes. What makes you think it will go out of the list?
On 5th if possible, my lord, because tomorrow will be very difficult for some personal reasons to appear before my lord.
Very well. I'll not take it. Don't press it. You are
I'm the appellant. They are the respondent.
So if the respondent are not there, then how will I be able to take it off and dispose of?
The urgency is that they have started, the income tax department has started the recovery. That's why I've mentioned it.
29th October, the petition was filed. Today is, my lord, December 24, 23rd. Till this time, my lord, the agency was not.
I have been mentioning this
29th
and that
October.
previous code also and this code also. After that, after 3 weeks, it has come up. I've been mentioning
So
every.
tomorrow, Mr. Dutt, you will not be there.
I don't have instruction. That is the problem.
Even for the bank, because suddenly it has come up in the list, in the top of the list. So bank is also, it is a matter of the PAN card, PAN number.
Let it be listed on the reopening day. I shall make one submission. I shall get instructions by then. Because I did not.
I don't have instructions for one more week. What will happen?
Till then, they did not.
No, till then I'll have to apply my mind. I cannot pass
It can be to be mentioned on the first opening date after the.
No requirement of to be mentioned. It will be at the top only because all the matters above that have been disposed of or dates prior. I mean, after the second week of January have been fixed.
It will be on second. They're asking for 5th.
Very well. 33.
No, 33 is
33, 36, 37, 5th January. Tomorrow I'm there. I'm not running away. Yes, so original site for.
Just said, madam, may I permit to mention item number 9? Mr. Neeraj said it's online, my lord. Item number 9.
Yes, it will be called on. Let him called on.
He will mention, my lord, on behalf of the petitioner.
It will be called on. Let it be called on.
Your Lordship, I want to mention one matter. All these 4 matters were listed yesterday, and the next date of hearing is 19th of Jan 2026. The ad interim stay was granted earlier. It needs to be extended till the next date of hearing.
If it was listed yesterday, stay was not extended.
No, Your Honor.
Listed under what heading?
Normal.
So you should have mentioned it that it should appear as extension of interim order. Merely it is appearing in the list. How will I know whether interim order is going to expire or not? You have to.
I apologize, Your Honor.
Give the slips.
All
How many matters are there?
4.
4.
Similar matter.
Extension is going to be এগুলো বলেনি কিছু You were there. Why did you not mention that interim order is?
Yeah, I was there. Yes, there was a lot of confusion. What is the next date of? So I missed.
Extension of interim order you require. You will not mention. What is the confusion in that? When is the interim order going to expire?
December 2025 or until further order, whichever is urgent.
You should have mentioned it. Deven kalke abar. Unnecessary these things are. You should be cautious with your matter.
I apologize.
Sub notice on the other side because they won't know.
We have informed other side.
Bring them, otherwise I will not extend.
Okay.
Yes.
No, one hour. 1 hour.
I'm appealing for the petitioner, my lord. My lord, petitioner doesn't want to proceed.
Withdrawal.
I have a written instruction.
लिखे नहीं
for extension of interim order. Item number 2, Millard, and claiming for the
2, 3, 4, and 5 are analogous.
4 and
5 are similar.
and 4. Originally, interim order was granted on the 14th of June 2023, restraining the hands of the corporation from causing any demolition work without due of court. Today, it has come up for only extension of interim order. So I'm requesting the lordship to kindly.
My lord, 2, 3, 4 is for only extension of interim order. But my lord, 5, including extension of interim order, there was another GA. My lord, on last occasion, your lordship directed further to serve the copy of the GA, which I served at the time of filing of that GA. Again, as per your lordship's direction, I have served the GA upon 2 sets of respondent. One is LICI, my landlord, and Kolkata Municipal Corporation. My lord, my GA, including my lord, all common prayer of extension, my GA relates to I am running a kitchen from the tenancy. That is Onadi cabin and Chorongi cabin, my lord, popularly known as my lord Moglai Khan, Kosamangsa and Moglai shop. My lord, on the heart, my lord, just on the my lord, southern gate of my lord Esplanade. My lord, your lordship knows, everyone will know. My lord, since
I don't know, I am a vegetarian.
Your lordship may not take it, but
If I don't know something, I don't know.
my lord, so my lord, since it is running a kitchen, my lord, so my lord, the outside wall of the kitchen get damaged. It required plastering.
Very well. Before the vacation, I cannot hear anything. I am extending it.
Last 1 year, this application is
What can be done? Let us see. Filing.
That was there, but they don't choose it to file it.
There are directions for filing affidavit in reply by somebody.
But for me, my lord, in item number 3, as regard
WPO 1253. 1253 of 2023.
It's also related to 2 and 4. The reply was also directed in 2. I mean 4.
No, 1253, nothing is required. 1256.
56 minute reply is ready here, my lord. I have already served. This is the reply with regard to the affidavit of LIC.
ঠিক আছে দিদি এই সবকটাতে কমন অর্ডার হবে উপরে লিখে দিন না একটাই অর্ডার
June 2023 in item number 2 and 4.
Interim order which is subsisting, I am extending.
Yes, yes.
That will be better. Instead of going into all that, I'll say subsisting interim order is extended.
No.
Just a minute. Let me first arrange it. All 4A, মানে সবকটাতে একটু আগে লিখুন. Since there is a subsisting interim order in all these 4 matters, let the said interim order be extended.
With regard to item number 9, my lord.
Sir, it is being called on. Please ask him to wait, not a problem. Yes.
The item number 6.
Number 6.
Yes. Yes.
We were discussing about the directions.
So should we do it after the vacation or should we after the vacation?
On 5th.
As no 5th, I think I have a matter fixed. No. আমাকে একটু ডাকুন তো। আমার ডায়েরি বলছি আমাদের একটা কন্টিনিউইং ম্যাটার দুটো আছে না, একটা 5 তারিখে আর একটা কবে ফিক্সড হলো, কবে আর একটা কালকে যেটা ফিক্সড হলো
4 তারিখ তো ওই
8 না এটাই তো 8 তারিখে তো বোধহয় অ্যাপেলেট সাইডে। Heard learned advocates appearing for the respect.
Item number 7.
Yes, Mr. Rajiv.
Yes, can be fixed on returnable on 2nd.
Yeah, very well. I'm making it not today, then it will appear after the vacation. I'm not passing any order. Should I pass an order?
No, not next. Manchu.
এটা after vacation করুন। হ্যাঁ।
Item number 8.
Not today, Your Lordship, after the vacation.
After vacation. I told you it will be.
Yes, my lord. That is
Because
correct.
I'm grateful, my lord. No, I apologize for the constant interruptions in this matter, my lords.
No, not a problem. Yes.
No. My lords,
Yes, Mr. Dutt, what about his?
I've given a copy. I've given a copy. Oh, you have got a copy? अभी दिए ना moment के.
my lord, may I just very briefly explain what has happened?
There is an order now. There is a give effect order passed.
Yes, my lord. My lord, what happened is, originally, this is a petition which was filed for assessment year 2004-5. For 2004-5, my lord, they determined a refund of 125 crore, which was sometime in October 24. My lord, that order is a part of the petition itself. Then, my lords, 125 crore for assessment year 4-5, it was after 2 rounds of litigation and 2 decades later that this refund was determined. So we were in obvious anxiety to get this money. We kept asking them, they did not give it. Number of follow-ups in CP-gram with PCIT. I don't want to trouble my lord with all of that. But ultimately, my lords, what they did is, they passed one more order on 18th June 25, once again determining the same refund. And then, my lords, on 26th June 25, they issued an intimation under 245 saying that we want to now adjust this refund, which has been determined against some purported demand for assessment year 21-22. We immediately wrote to them, no, this refund cannot be adjusted against this demand because this demand has been stayed by the tribunal. We also enclosed a copy of that order. Despite all of that, they have adjusted this refund against this 21-22. So, my lord, my prayer in the writ petition was that this adjustment itself is completely wrong, and therefore this adjustment should be reversed and I should be getting this refund of 125 crore. Now, as a pure practical via media, my lord, what I'm saying is today now he has passed an order for 21-22 also, because there also whatever demand was there, all that has been nullified because the tribunal has passed a favorable order. And this order which my learned friend has just tendered to your lordship is an order which recognizes that fact, and it has determined a refund of 123 crore for assessment year 21-22. Now that refund also, my lords, was determined in November of this year, last month. But there also now they've said issued some 245 intimation saying that we want to adjust this and we want to adjust that. Now, my lord, my short prayer is that those amounts are also not required to be adjusted, because the officer himself says that these demands are not collectible on the portal. These demands are wrongly being shown, and still he wants to adjust those demands, some 8 crore, and for that he's holding up my refund of 123 crore. My lord, may direct him to just give this refund that can put an end to this matter, my lords.
Where in the writ petition have they said this? Where is the order by which they have sought to adjust this, or they are holding this back?
Yes, my lords. So the adjustment which they've already made, my lords, is at page 58.
No, this order dated November 25th of November 2025 has come subsequent to the filing of the writ petition.
That's right, my lords.
That does not feature in the writ petition.
No, my lord, that has come later on. It's a current 1 month old thing, and we came to know about it only.
After this order, after this also, you are aggrieved.
No, my lords, but they are not giving me this refund, my lords. This refund they are determining, just like they determined a refund last time, but then they've adjusted again something or the other. So, my lord, my thing is that you determined a refund, you give it to me.
No, if as of now, I don't see any reason why this is not being withheld. There's nothing in the writ petition also to indicate there can be nothing, in fact, because this is subsequent to the writ petition, that this amount of 123 crore which is said to be payable to you has been, because this is issued by the authority itself, saying that it is to give effect to the order under section 254.
That's right, my lords. So he's determined a refund. Now this determination was on 25th of November 25. Today we are, my lords, already 1 month from then. So far it has not come to me. My lords may direct them that they should pay this refund to me within a period of 1 week, 2 weeks, whatever they like.
That they will pay definitely. Why? What is the reason of them not paying this? Because I don't see any reason. In the writ petition also, where is this that they have withheld it something? Something, whatever, if an appeal was pending or something was held back somewhere, now there is an order saying that you are entitled to this.
Right, my lord.
So I don't see any reason why it will not be paid.
Right, my lord, but the thing is that for 1 month they have not given it to me. My lord may then direct them that they should pay me this refund.
Pass an order, my lord. Pass an order directing
Pass an
them to-
order directing them to pay me this refund, my lord. That will be...
Again, they will be adjusted.
No, if they are entitled to adjust, I cannot stop them from adjusting. But yes, you are entitled to this as of now.
That's right.
I cannot right now speculate as to whether you are not liable to anything else, or they are not.
No, my lords, there is one intimation which has been sent after this refund was determined. My lord, my learned friend will just tender that a copy of that. That, my lords, is dated 18th December 25, just last week. They've sent this intimation. My lord, will have that.
And there were a copy of that proposed refund, my lord.
My lord, this is the intimation which has been sent for assessment year 21-22, which is the very same thing. And my lords will, if my lords will have the third page, they are saying that they want to adjust it against the purported demand of 2007 of 8 crore 84 lakhs.
How can I immediately on seeing this without hearing anything from them stop them from doing this?
No, my lord, because the AO himself says that this demand is not collectible. In this very intimation which they have sent, my lords, just to the left of this amount of 8 crore 84, AO's response is that this demand is not collectible.
Then where is the reason for you to be apprehensive?
My lord, but this is what they've issued. Now, despite the AO having said that this demand is not collectible.
If everything is in your favor, then there is no reason for you to be apprehensive. Where is it written that it is not collectible?
My lords, there's a tabular statement with the heading that details of outstanding demand and interest payable under 220 subsection 2. My lords have that. So it says that is the AO's response. The taxpayer's response was that it is not collectible. Even the AO has said that this is not collectible. And still they want to adjust this amount of 8 crore 84 against my refund of 123.
If then in that case, I will have to ask them to come with instructions, because I cannot sitting here immediately without taking anything, decide and say that.
Milords,
I can only direct that whatever is payable to you in law should be paid immediately. That I can put.
Milord, I'll be satisfied with that. Milord, they may, if they want to, they may adjust this refund, they may withhold this money. I will take my whatever steps which are available to me, I will take my steps and address this concern separately. Milord, but insofar as the balance amount is concerned, the balance amount of 123 minus this 8,
Very well.
that may be given, Milord.
The petitioner seeks issuance.
Yes, my lord. This assessment year 2021-22.
No.
Our repetition related to 2004-5.
Your repetition was for 4-5.
Yes, my lord.
Right, Milord. Milord, the petition was for 4-5. They made this wrongful adjustment against an demand of 21-22. I'm saying that I'm okay if they give me this refund even in 21-22, then I don't need to trouble my lord with this petition
And
of 4-5.
where do I get that? Where do I get that this amount which was refundable in respect of 4-5 was adjusted against 21-22?
Right, my lords. That is at page 58, my lords. So first they gave me this refund, that they gave me this intimation that your refund is proposed to be adjusted against an outstanding demand. If my lord will see on the next page, page 59.
Sir, please wait, please listen to the order. When I ask questions, please then elaborate.
Yes,
it is submitted by the learned advocate appearing for the petitioner that the amount, the aforesaid amount, which was refundable to the petitioner in terms of the order dated October 17, 2024, in respect of assessment year 2004-05, was sought to be adjusted by the respondent revenue authorities against demands pertaining to assessment years 20-21.
my lords, 21-22.
21-22. 21-22. Full stop. Paragraph. The petitioner submits that such adjustments could not have been made. Full stop. Paragraph. Mr. Dutt, learned advocate appearing for the respondent revenue authority, hands up to court a copy of an order dated November 25, 2025, wherefrom it appears that the demand raised against the petitioner for the assessment year 2021-22 has been done away with, and the petitioner is entitled to a refund of rupees 123 37, 46, 653. Is that correct?
That's
Yes.
right.
The entire demand in respect of 21-22 has been set aside.
My lords, it has been satisfied by using this refund as a payment against this. So if my lord will have this order of 21-22, if just above 3 lines above this 123 crore, my lord will find this figure of 119 crore, which is the amount of refund of 4-5, which has been adjusted against 21-22. This 119 crore, 39,60,351 is the amount of refund which was available to me in 4-5, which has been wrongly adjusted over here, despite there being no demand. And therefore, there is now a refund of 123 crore in 21-22.
No, so this 4-5 adjustment against demand of 4-5, this demand stands or this 4-5 demand has also gone?
My lord, so in 4-5, I had a refund, which they said I'm adjusting against a demand of 21-22. Now
Very
there
well.
is
Now
no
demand of, sir, please answer the query of the code. Demand of 21-22, does it stand today or it has gone?
It is gone.
Yes, that is what I was asking.
It is gone. I apologize.
That was my question. The demand has been done away with by the tribunal. Isn't the entirety of it or part of it?
Whatever was a disputed demand in the entirety has gone away.
That is a fact.
Right.
Very well. Next. Done away with by an order passed by the appellate tribunal in what was the number of the appeal in which the demand of 21-22 done away with?
My lord, the
2610.
It is in the bottom, my lord. IT number 2610.
IT
Poll of
number
2024.
2610/2024.
Dated 26 August 25.
Dated August 26, 2025. Full stop. The order dated November 25, 2025 under section 254 read with section 143 within bracket 3 of the Act has been passed to give effect to the order passed by the appellate tribunal to the order dated August 26, 2025 passed by the appellate tribunal in the said appeal being ITA 2610/2024. Full stop. It is submitted by the learned advocate for the petitioners that subsequent to the passing of the said order under section 254, said order dated November 25, 2025 under section 254 of the said Act of 1961, the petitioner has received another intimation dated December 18, 2025 from the Income Tax Authority, which shows that an outstanding demand in respect of assessment year 2007-8.
Yes, my lord.
But at the same time, the same has been stated to be within inverted comma not collectible by the assessing officer. It is submitted that in such view of the matter, the petitioner is entitled to the said sum of rupees 1, 23, 37, 46, 653 in terms of the order dated November 25, 2025. Full stop. Paragraph. Having heard the learned advocates appearing for the respective parties and having considered the material on record, this court is of the view that since an order under section 254 read with section 143 within bracket 3 has been passed by the revenue authorities on November 25, 2025, the amount indicated in the said order as refundable to the petitioner should be refunded to the petitioner unless the authorities can justifiably withhold the same against any justified demand of the justified outstanding demand of the authorities, comma, in accordance with law. Full stop. Paragraph. If the amount mentioned in the order dated November 25, 2025 is not adjustable, comma, the same should be refunded to the petitioner as expeditiously as possible, preferably within a period of 4 weeks from the date of communication of this order. That will do.
My lord, may keep this petition pending for compliance maybe after 6 weeks or something like that.
I'm just you come up again if they have not done it. Plastic ki likh len ekটু পুরো. Yes, I have clarified that if the amount which is mentioned in the order dated November 25, 2025 is not adjustable or collectible, the same should be refunded.
Right, my lords.
Because here, sitting here, I cannot stop them also. If there is a collectible demand that they have, or there is an adjustable, so I cannot, I mean, prejudge
Certainly,
that.
my lords. Certainly, my lords. Certainly, my lords. My lord, I'm very grateful.
WPO 715 of 2025 stands disposed of with the above observation.
My affidavit shall be kept on record, my lord.
Small matter of fixation of a date for early hearing of the appeal, my lord.
Yes, please.
Yes, my lord. Serial number 14, my lord.
1/4.
Yes.
देखिए 1/4 का कॉल कर दीजिए. भैया 5 मिनट बैठ.
Yes, my lord. Assessment order passed in May 19, 2021 for the assessing year 18-19. Thereafter, my lord, appeal was filed on May 13, 2021.
1/4.
Yes. An addition was made by
Let me have the file.
Yes.
10 may be kept after the check.
Then where is Mr. Day?
Yes,
Yes. 10 after the vacation.
My lords, 10 may be taken up after the vacation. I cannot say there's any really hurry in this.
10 after the vacation.
Grateful, my lord.
Not second.
14 has been called on. Ask your other side to be ready. I'll take up.
Number
11, I have not done anything. 14 ta din file. Yes.
Yes, my lord. The yes, my lord. Assessment order passed in April 19, 2021.
This petition.
Page 12, my lord.
This petition.
That Gamma part may not be.
Not a problem. I will not dispose of any matter expertly. Next,
But Lordship will take small matter, this.
small matter, big matter, any
Yes.
very big matter, I will not.
The lengthy matter may take after vacation. Get to know, get to know.
চলুন আরেকটা কি 11 বলছেন? Yes.
Here, my lord, I am praying for a consideration of a representation, but I made under section
Yes,
110A
Mr.
of
Right.
custom section.
Consider his representation. Why are you not considering?
My lord, past similar orders, my lord. This matter, same 110.
That one, what? দেখি কি আছে কি অর্ডার দেখি ওটা দেখি
দাও দেখি একটা।
It is the same 110A matter.
It's a 110A matter, my lord, slightly different, my lord, because the so-called notice has been issued in the meantime. My lord, what I propose, my lord, let the authority concerned dispose of my representation. In the meantime,
Your representation is for release of goods.
yes, provisional release under section 110A. Now, my lord,
Please consider and dispose of it.
Yes,
লিখুন লিখে নিন the petitioner Give his name. Because today I did not have, then again I was given. What is the urgency? What is the urgency? I need to know the urgency that it should be heard tomorrow. It cannot wait for one week, because after 1 week again we will assemble. No, you tell me the urgency, only then I cannot. Because every matter, if it becomes urgent, it will become difficult. The list is overflowing as it is. I am a slow judge, so I take time to dispose of matters. That I understand. I granted leave to file, not to get it listed and moved before the vacation. Thank you.